Number 454. Today's list, my lord. Yesterday I mentioned, my lord, this is regarding unauthorized construction on the, my lord,
Are
PWD
you
road.
mentioning upon notice?
Upon notice, my lord.
May I have Lordship's kind indulgence to mention one extremely urgent matter, my lord. Lordship will recollect that I have mentioned it on Monday. My lord, this is a matter, my lord, where my lease has been terminated and railways have issued a tender notice saying that it will be opened on this Monday, my lord. So, my lord, I have filed and I have intimated my other side on 2 occasions, my lord.
Are you
Fi-
mentioning upon
File
notice?
is here, my lord. My lord.
Are you mentioning upon notice?
Yes, my lord. Upon 2 notices.
Give them.
Only I beseech your lordship one aspect, my lord. If your lordship takes this matter at 2 p.m., my lord, I ensure appearance of my other side. I ensure 2 p.m. my lord. It's Monday, my lordship. Friday is a day of uncertainty, my lord. That is the reason.
No. Why
When
not, sir?
lordship tomorrow, lordship will takes or
It's not a day, there's no uncertainty about 2 p.m.
in that case, my lord,
There's
only
uncertainty about
one, my lordship, one request, my lordship. If lordship takes it at item number 1 at on Friday, 2 p.m. This much, my lord.
Friday, top it up.
Grateful, my lord.
My lord, may I permit it to mention, my lord, for upgradation of today's list, my lord, 3 matters are similar. The extension of lease was been expired during the pandemic situations, and their representation is not considered till now.
Are you mentioning upon
Yes,
notice?
my lord.
Give them up.
May we permit to mention?
Unauthorized construction, my lord.
Upon notice?
Milord, upon notice, I am mentioning this matter. This matter was mentioned in the month of November, not appearing. Your lordship allowed that time. This is
Hearing that?
yes, my lord. No, it is motion matter. Motion matter. Item number 595 of the combined list.
Give the number.
May we
It was-
mention one matter for
আগের বারে
matter
কিন্তু এটা
for
মেনশন করা
upgradation,
হয়েছে
my lord. Item number 505. Lord, I'm mentioning upon notice, my lord. The urgencies that the Department of Public Health and Engineering has encroached into the land of the petitioner, and they are almost at the verge of completion of the project work, my lord.
My lord, may I permit to mention one matter, my lord? 440.
Yes.
My lord, upon notice, I am mentioning item numbers 485 and 484 of your lordship's list today. My lord, the BLRO is rectifying the ROR without giving any opportunity of hearing to
This
the
court
parties.
doesn't have jurisdiction, sir. It's under the specified act.
But-
BLLRO rectifying the ROR is under
My
the
lord-
Land Reforms Act.
My lord, pursuant to a notification issued by the Secretary Land and Land Reforms Department, I am
This court
I am-
doesn't have
I am
jurisdiction.
challenging the notification of the
This
Secretary.
court still doesn't have jurisdiction. Shantanu, to be mentioned, release of. It has to be released, sir, because this court will not have jurisdiction under the under the Land Reforms Act. It's a specified act. You have to approach the appropriate forum. Are you mentioning upon notice?
My lord, may I permit to mention item number 444 of the monthly combined list, my lord? Respondent said, without hearing me, my lord, order was passed for eviction, my lord. With notice, I am serving, my lord.
Upon notice?
Yes, my lord, with service notice to the other side.
My lord, upon notice, I am mentioning my lord, item number 162. 64, my lord. My lord, execution of interim orders.
Execution of interim order.
My lord,
Yes, sir.
my lord, item number 508, my lord, I was appearing person in that person. My lord, last occasion, my lord, directed to again serve the notice of the state. The notice has been served. My lord, today actually is part of matter is fixed at 2 p.m. So again, I will not be able to. So my lord, is kindly adjourn this for a week.
It's appearing today.
Today,
If
5
the matter is called, sir, I cannot take up.
Oh, my lord, I'll send some for you.
Yes, please.
My lord, may I be permitted to mention a matter for upgradation, my lord? Item number 382.
Upon notice?
Upon notice, my lord. My lord, this is the third round of litigation, my lord. My lord, even after the 14T3 proceeding, my lord, of the Acquisition Act, my lord, we have retained the property, but we are not able to sell because the authority has put some conditions on it, my lord. And we have opted for RTI.
14T3 under the Land Reforms Act.
My lord.
This court doesn't have jurisdiction, you have to withdraw the writ petition.
My lord.
I'll fix, let it appear as to be mentioned tomorrow, allow you to withdraw. Land Reforms Act, you must be aware,
Well-
it's a specified act, you have to approach the appropriate forum. To be mentioned, Shantanu.
My lord, may I permit it to mention, your lordship, the matter I was trying to, my lord, leave to file the matter, my lord, on 22nd 11/2023, my lord, there is a Vidyasagar colony that has to be demolished within 15 days, my lord. I was trying to leave before your lordship. Lordship was directed me to file the read application.
And
I have
come
sub,
back. Yes,
my lord.
yes.
My lord, I have filed
Are
it,
you
and my lord, I
mentioning
get
the
the,
notice?
my lord, I have served the all notices to the concerned respondent authorities.
You are mentioning today upon notice to the respondents?
My lord, yesterday, my lord, I have served the notice of the main read
Of-
petition. My lord.
Of mentioning, I'm asking. Not the
Mentioning, my lord, no, my lord.
mentioning has to be done upon notice.
My lord.
Please see the first page of my.
My lord.
Lord, may I be able to mention the item for upgradation, item 392 of the monthly list, Lord.
Upon mentioning,
But
upon notice to the other side.
no, Lord, only state respondent is that I shall. And
It's not accepted.
oh, all right.
Lordship, may I be permitted to mention for upgradation? No, upon mention, upon notice, my lord.
Yes. For
For
what?
upgradation, today's list,
Why?
item number 161. My lord, this case pertains to, my lord, the compensation to be received by the petitioners. There are several petitioners whose compensation has been stalled, and as the order passed, we filed a contempt separate proceedings has been issued. They filed a reply stating that they have given the compensation without calculation. We have challenged this order. My lord.
May I permit it
Grateful.
to mention one matter, my lord, for restoration of,
Upon notice,
not my, no, my.
come back up after. Yes.
With permission for mentioning, Lordship, this is an application for the substitution.
For?
Substitution.
Have you served the other side?
No, Lordship, I shall
Please mention upon notice.
Lord, this matter, my lord,
Be allowed without notice to the other side.
upon notice, I'm mentioning, my lord, the item number 122, my lord. The claim for upgradation, my lord.
Why? What is your urgency?
The petitioner is a senior, very senior citizen, my lord. My plot has been reallocated, my lord. Already.
Give the number. Give the number.
Your Lordship, I want to tender apology, Your Lordship. I'm not mentioning upon notice. Your Lordship, it is the matter of Rubita Ghosh, Your Lordship, and this matter is appearing in the monthly list of as item number 427, Your Lordship. So if Your Lordship may be allow Your Lordship.
Mention upon notice. You have taken up their brief?
Lordship, I have Lordship, only one issue is that Your Lordship, there is a land dispute, and Your Lordship, that needs to be redressed before the learned court below. But in this application, Your Lordship, they are seeking one information about one DAG number, Your Lordship.
Can that be given by this court?
Lordship, that determination will be under the residuary matter. It should be filed. But Your Lordship, I have taken the instruction that they have mentioned this matter before the Honorable Chief Justice, and Chief Justice has assigned this court, Your Lordship, for this matter.
What is the number?
Chief Justice has mentioned this. Chief Justice has quoted it. Your Lordship, they have been said that this court will be taking this matter, but unfortunately, they are seeking information, and that information will be.
Court cannot deal with.
Lordship.
Do one thing, please.
Lordship.
The other side, please mention upon notice tomorrow.
Lordship.
Yes. Let
In
me
this
see the files.
Lordship.
Please mention upon notice to the other side.
Lordship.
So the
Lordship.
other side
I
can
will.
also apprise the court to
Lordship.
what has happened exactly.
Lordship.
Right?
Definitely. Much grateful.
And thank you for taking the brief. They were helplessly moving around actually. Yes, call the day's list, please.
Item number 1. My lord, item number 1, my lord, I am appearing on behalf of the contender, my lord, with my learned senior, my lord, Lalit Mohan Mahato. My lord, kindly, my lord, adjourn the matter for another 3 weeks, my lord. The order will be.
It was appearing yesterday.
No.
My lord,
I tell your lordship,
representation. There was a.
Milord, I tell your lordship, Milord. Milord, on 30th
November,
November, Milord, this matter appeared for the first time. Lord, 30th November, Milord, my lord directed to serve a copy of the petition. Lord, on that day, my lord, I categorically submitted that before Milord admission, Milord, I already served. Milord, thereafter, my lord also again directed that no, you go and serve again. Yes. Lord, now, Milord, when I went to serve, Milord, one of the alleged, there are two contemners. One is there. Another Milord, initially it was Shamol Kumar Pal, LA Collector, Purva Medinipur.
Now, my lord, new incumbent has come in, my lord, his name is Tapan Kumar Mondal. Not only for that purpose, my lord, this matter has been mentioned, only, my lord, Tapan Kumar Mondal's name is to be added, my lord, in place of
Sanjay Singh.
no, in place of Shamal Kumar Pal, page 6, my lord. Page
He's
6.
the present land acquisition collector.
Yes, the Tapan Kumar Mondal is now, my lord, the present land acquisition collector. My lord, his name is only to be added in place of Shamal Kumar Pal.
Let
This
this,
is the
let this correction be done. Yes? You are appealing for the alleged contempt.
Contender number one, my lord. Is
So the person has changed.
I do not know, my lord.
Petitioner knows, you
Yes,
do not know.
yes, he is changed, my lord, because we tried to effected service on that person, my lord. He said that Tapan Mondal, my lord, he said that no, it's in the name of Shamal Kumar Pal, I will not accept service. Sanjay Singh has accepted service.
So let the name be changed.
My lord. My lord, only one thing, it should be not be changed, my lord, it should be added.
Added.
Yes, because this, my lord, I have also grievance against this person.
Yes, because during his tenure, this has happened.
Yes, not only that, my lord, I will demonstrate that how a state officer, my lord, of a LA collector, my lord, is doing unduly work, my lord. I will show that. He will be alleged contender number 3.
The applicant petitioner seeks to add the name is Tapan Kumar?
Tapan Kumar Mondal.
Tapan Kumar Mondal. The present land acquisition collector and special land acquisition officer, comma, Purbo Medinipur, as the third respondent as the third alleged contemner, respondent, as the third alleged contemner in the contempt application. Paragraph, such prayer is allowed. Paragraph, the cause title of the contempt application be amended accordingly. Paragraph, the applicant petitioner is directed to serve copy of the contempt application along with annexure thereto upon the added alleged contemner, and file affidavit of service on the adjourned date. Paragraph.
Lord, in course of today, my lord, I need to do it today.
Just do it. No,
Lord, yes.
Yes. Paragraph, let the matter appear under the same heading on 10 January.
No, my lord, 14 December is fixed, my lord. My lord, 14 December is fixed, my lord, kindly read. 14 December is fixed, my lord.
Returnable.
And only one thing, my lord, so far as lord, my learned friend is also already appearing, my lord, then again, my lord, service upon one be dispensed with. My lord, he is already appearing. I cannot serve that person again, my lord, he is already appearing.
See, this is a contempt application. I cannot dispense with service.
My lord, how can I serve that Shamal Kumar Pal one again? Because he is not there. I don't know where he is.
Who is appearing for 2?
2, I am
for 2.
Yes.
Paragraph since alleged contemner numbers 1 and 2 are represented, comma, service upon them is dispensed with.
Deeply obliged, my lord.
Huh? Each other.
নামটা দিয়েছিস এটা ফাইলটা ওখানে নে ওখানে চল আমি বলে দিচ্ছি কারেকশন করতে হবে এডিশন
Next.
At number 2.
My lord, this matter is already been released by
It's a group live matter.
It has been released on 16th October 2000.
Not by this court.
No.
That was the coordinate bench.
By a coordinate bench, yes. Since the matter pertains to group 9 of the classification list, comma, the matter be released due to lack of determination.
Grateful, Lordship.
Number 3.
This is my application for contempt. I'm filing my exception. I have many things to say. 8 occasions adjourned on the ground of appeal. Ultimately, appeal has been withdrawn. Appeal has not complied with. No step.
I want to submit to your lordship that I one application before your lordship in June, in the month of June, that is appeal was filed by. Appeal was filed by learned friend, my lord. The advocate learned friend, that is Sushaman Sendukku, was that advocate. And for that, my lord, the Honorable Justice Division Bench, my lord, that
we want, we withdraw the appeal, my lord, to file a fresh matter. Now, my lord, within one month as we enter file that appeal, my lord, we want to get, my lord.
Comply with the order.
No, my lord, to get leave from the honorable division bench. Today is, my lord, our appeal and section 5 is ready, my lord.
Last day also same submission was made.
Admit around that. মই তোমাকে তো সব বলতে হবে my lord, after that, my lord, we are, my lord, if your lordship will see, that is ready is, my lord, to file appeal. Well, today is also my learned friend, my lord, mentioned that matter before the division bench, but the division bench refused that within 1 month we are not filing that appeal. Division bench was pleased, were pleased to direct us to get a certified copy, my lord. We have already filed for certified copy of the same, my lord, but we could not get that same, my lord. So, my lord, I pray some time. Only for that is
29 September 2022 was the order. Now, I'm not disputing that whatever my senior friend has submitted, I'm not disputing that. But the internal, my lord, difficulties will not exonerate them from compliance. Let them comply.
Convincing the court.
My lord, I am coming with the, my lord, I am not.
He has almost convinced me also. But my client is in court, they are suffering for a very long time. Let them comply subject to result of the appeal.
My lord, we must.
Till date, there is no appeal in the eye of law.
If we want to file, if we file the appeal, my lord, within 5 days or 6 days, my lord, that will be.
That appeal was also beyond time. The first appeal was also beyond time, section 5, with section 5. But incompetently filed,
Now it
withdrawn.
is absolutely beyond time.
Beyond time.
In violation
They will
of
pursue,
section
they will file section 5. Let them comply subject to.
With
I'm
the-
not getting my
with the-
compensation.
They are ready with you, sir, not.
I know, my lord. I know, my lord. Otherwise, my lord, if the appeal is not filed, give me some time, my lord. We must comply. We are bound to.
I'll allow it as a last chance, Mr. Dev. Otherwise, rule has to be issued.
Yes, my lord. The lordship will issue rule.
Exception submitted on behalf of the petitioners applicants is taken on record. Paragraph learned counsel for the alleged contender seeks further accommodation to file to prefer an appeal to prefer a fresh appeal before the honorable division bench. Where the earlier appeal was turned down on technical grounds. It was turned down on technical
grounds. Appeal was filed.
Paragraph, let the matter appear. Paragraph, as a last chance, the prayer is allowed. Paragraph, let the matter appear under the same heading on 15 January.
Kindly record that for a long time the petitioner is suffering because the land was not supposed to be returned in early 2000. Much of them.
ওটা একটা লাইন অ্যাড করুন learned counsel for the ওই যেখানে টাইম চাইলো তার ওখানে প্রথমে petitioner submission learned counsel for the applicant petitioner submits that the petitioner has been suffering since long as the order under contempt was passed on
September 2022 and the land was not previous direction of High Court is of 2007. They were supposed to return the land. I'm fighting from 2007.
Submits that the petitioner has been suffering since 2007 when his land was taken away arbitrarily and illegally
Directed to be returned. Directed to be
by the
taken away.
government, and this court directed return of the said land to him. Therefore, seeks accommodation as the last chance.
My lord, that was returned, but that was not physical. As a physical,
This court, Honorable High Court.
He was not in the physical position, my lord. Only for that is there is some person was sitting there.
I've recorded his submission. That's it. Next.
Number 4.
Number 4, my lord. The order dated.
May I file the my lord, report, affidavit of compliance, my lord. What happened is this, my lord, on 3 occasions, my lord, we have sent letter and asked them to come and collect the money from the department and submit your particulars. My lord, 3 occasions
they didn't turn up. But last occasion, my learned friend had mentioned before your lordship that the estimate has not been sent. That's why the last occasion estimate after the passing of the order estimate and the letter has been sent to the
affidavit, my lord, and we'll come back. And my lord's order, my lord, on 29.
You say that it is complied with?
I've said from our end there is no, my lord, latches, my lord. We have said we are ready to pay the compensation to them. On 3 occasions we have sent letter and asked them to come.
Submit your affidavit of compliance today?
Yes, yes.
See, that be so, then it has been complied.
Yes.
Let us consider the affidavit, my lord, and come back, my lord.
Do that, please do that.
Let a copy now.
Affidavit of compliance submitted on behalf of the alleged contender is taken on record. Paragraph, learned counsel for the applicants / petitioners seeks to peruse the said affidavit. Paragraph, let the matter appear under the same heading on. Come back on 15 December.
But let it be on January, my lord. Let it be on January. My instruction is for January.
15 January.
A copy to the
This indicates compliance.
Yes.
The submission indicates compliance.
I have stated all that.
But will you consider?
Next.
At number 5, I beg to appear on behalf of the petitioner, my lord. This is the exception. But the matter I'm telling your lordship, the private respondent filed a writ applications for removing the illegal encroachment, my lord. Now, without disclosing the civil suit between us, the my lord directed to consider and dispose of by giving a reason of opportunity to all the affected persons.
With regard to private property, personal property.
Yes, I'm telling you, lordship, without disclosing that this order.
But the private, who is appearing for private?
I am private respondent.
Now, my lord, what happened, my lord? The 10-2 proceedings started, subsequently 10-3. Notice was served to my husband. Actual landowner is myself, petitioner herein. Now, my lord, challenging that order, petitioner and his husband moved an appeal under 10-4. Now, at the time of hearing, I will satisfy your lordships regarding 10-4 order. Thereafter, your lordship directed to file a report by the state. Now, my lord, will kindly take time to look at the state. Report in form affidavit on behalf of respondent number 8, my lord.
Yes.
Well, got, well, do you kindly see page 2?
Yes.
Your lordship will find that I state that after necessary inquiry from the land records, acquisition, subject and such. Last line, when acquired in connection to Defense of India, case number eto under the Defense of India Act. Page 2, Roman 1. Under Defense of India Act.
Yes.
Well, the document annex also shows that it has been acquired under Defense of India Act. Well, you see, well, page 4. My land is 111147, 34. From bottom, second column.
Yes.
Well, got it, my lord?
Yes.
Now, I will kindly take table to look at my exception to the report.
Yes.
Exception to. Let us see. I have annexed the Defense of India Act.
Yes.
Exception in response to the affidavit 8. Now, at first, we will kindly see the purpose of Defense of India Act, my lord. That is at page 7. I got it. Column 3. It shall remain in force during the period of operation of the proclamation of emergency issued on 26th October and the for period of 6 months thereafter.
But it will not affect the, there are other provisos of.
Yes, yes, my lord. The previous operation or anything, well, it is in 1962. It is 1962. Its effect.
Even after expiry, these aspects will not be affected.
Yes. Now, my lord, you kindly see there is a provisions, section 29. That is at page 22.
Yes.
Column 3, whenever any property is requisitioned under 1, the period of such requisition shall not extend beyond the period for which such property is required.
You are reading
29,
29, yes.
page 22, section 29, subsection 3.
Yes.
Now, my lord, there is a provision for acquisition, that is page 24, section 36.
Yes.
Any movable property which has been requisitioned under section 29, my lord, earlier I show you, in the manner hereinafter provided be acquired in the circumstances by the government specified below, namely, where any works have, kindly my lord take a note, during the period of requisition been constructed on, in or over the property wholly. So, my lord, it is admitted positions, the land is in possessions of the petitioners. So, there is no construction on that period of time. Now, my lord, your lordship, this is the state's submission that under Defense of India Act, the acquisition was done. It cannot be done because it's, your lordship, I will show you the section 3. The purpose is for the periodic, for 6 months.
No, no, no. Please come to the remaining part.
Yes, my lord.
A, B, and C. Even after expiry of operation, these remain.
Even after when, my lord? When the property was acquisition under section 36. Kindly see, my lord. When a property requisitioned and acquisition, then
Where is that stated? Only in case of acquisition it remains.
well, kindly see, my lord.
Please come to 3.
Yes, my lord, I am coming to this. It shall
Operation of anything.
the previous operation. No, there is no question of previous operations. His statement, I will show you his orders. His order, I will show you, lordship, that
It was admittedly requisitioned during the subsistence of this act.
no, my lord, I am telling you, lordships. I came to know I have a 34 decimal lands. Out of that, but 22 decimals acquired, 12 decimals I have. Now, my lord, I record of right was published in 2 decimals. I filed an application for correction of record of right. Subsequently, this private discipline filed a petition. I came to know that my land has been acquired. This is the positions, my lord. I got that land by virtue of a gift from my mother. Now, your lordship will see that the previous operation or anything done duly done or suffered under the act. But nothing was done under this act. Here the report says the Defense of India acquisition. Only 2 documents submitted. Like, kindly see the report.
So that was under the act.
Kindly see that it should have to be requisition first, thereafter acquisition.
This is a possession certificate, nothing else.
This is in 2 documents. 1 document probably that is not verified also. Second document, no signature.
There is only 1 document annexed to the report. That
2
is
documents.
a possession certificate.
Yes.
Nothing else.
So, my lord, how the acquisition nothing was. Now, my lord, lordship will see the petition. Petition.
My lord, anything done means, my lord, here that the land acquired, subject to your lordship kind correction. Any
Only acquired, anything done is.
it means
doesn't
acquisition to the land.
confined to acquisition only. It may be requisition.
It may be requisition, but requisition, I told your lordship, requisition of for specific purpose. Clause 3, I show your lordship. For specific period.
This is no. This goes beyond the specific period. That
My-
is what I want to say.
My lord, kindly see, my lord.
Yes,
So-
please make your submission. I'll pass orders.
My lord, now, my lord, kindly take time to look at 10-4 order. So,
At page.
at page 38, my lord, of writ petition. My lord.
Yes.
Well, kindly see the submission of the assistant, page 38, my lord, third paragraph. The submission of the assistant engineer, Islampur High Division, such and such, and reports of the BLRO, such and such, clearly reflect about the fact of encroachment over public land. My humble submission, my lord, kindly see from the entire order. Your lordship will not see how the property was acquired, under which provision it was acquired, how much compensation was given, to whom compensation was given. Nothing. Kindly see order. My submission was not at all dealt with.
Where is your submission recorded?
My lord, my submission is instant appeal, page 34. First of all,
Yes.
page 34 starts with nothing dealt. Observation portion, I will show your lordship.
Is there any observation with regard to the Defense of India Act in the order? 10-4
Nothing.
Order?
Nothing. Kindly see order. Other exception.
Let the state respond to this.
Well, only one thing in addition to your lordship, my first point, I think, my lord. My lord, the state has himself admitted the acquisition was done under Defense of India. There is no doubt about that. So acquisition must be in terms of section 36, not any other section of Defense of India. So 36 says, my lord, whatever your lordship, I will show your lordship what the 36 says. Considering the 36, my lord, if the 36 is done, then it has been validly after 6 months also. This is my super I have understood, subject to your lordship. If the 36 has complied with, then it will be operative after 6 months also. Now, my lord, another thing, my lord, during hearing, my learned friend shows that I have already admitted in my plaint that I have 32 decimals acquired. Respondent number 11, in his report, in his exception, filed it. Now, how he misled the court from day one, I am telling you, lordship. Kindly see my exception one.
Exception to which exception?
Second exception to the respondent number 11. Second exception. Just today I filed it. Exception. ওদের exception টা তো
Yes.
আচ্ছা my exception, kindly see, suit was filed in the year 2011. Kindly take table page 7.
Yes.
In the on 15th of January 2014. Got it? My exception, page 7. Information slip.
Yes, yes.
উপরোক্ত amendment petition 15/1/2000 তারিখে allowed হয়েছে কিনা? Yes, my lord. Amendment was done 2014. Now, my lord, prior to that, the schedule was also mentioned. 12 decimil. Kindly see bottom page, page 6. 22 শতক বাদে 12 শতক যার উত্তরে bottom portion, man.
So, in respect of the same property, civil suit is pending.
Yes, civil suit pending. Earlier occasion, what he said, my lord, kindly take his affidavit. 11 says that I myself admitted that I have the acquired land is 32 decimal, but entirely misleading the court that amendment was done subsequently. And from day one, my lord, they are misleading the court, although they have no status in this matter. Locus, which is petitioner between the state. Kindly see.
If the same property is involved in the civil suit, how can the writ court intervene?
My lord, the petitioner suppressing all these things, obtained order subject to your lordship kind correction. Now, my lord, 10-4 is, I am challenging that I have no other options. I have to come before the writ court.
So you say that the petition, the private respondent
Yes.
has suppressed the.
Yes, I have the
suit.
petition, nowhere averment regarding civil suit.
And it's the same property. How
Yes.
can it be dealt with? What is the plaint of the civil suit?
Print annex, C annex,
Declaration.
declared suit, madam. Filed by me,
Filed by you,
my lord.
Ajima Bibi.
Yes, my lord. And in a writ petition, I am not made party. My husband was made party.
What are your prayers in the suit?
Restraining him, my lord. Page 11. And permanent injunction. Declaration and permanent injunction. Injunction on also?
So this is part of the civil suit, the same property. Yes, state.
Yes, my lord, whatever the my lord petitioner has stated, my lord, what I understood, he is just assailing the acquisition order, acquisition process, my lord. Kindly consider this. My lord, by this 226, generally petitioner prayed for forwarding of the 10-4
That is
order.
clear.
Magar, whatever he submitted, my lord, I just understood, my lord, that he is, my lord, harping the my lord, acquisition process, which has not challenged here. Kindly consider this. Secondly, my lord, kindly, my lord, come to my lord report.
Yes.
Before that, my lord, no, the 10-4 scope is very limited. In 10-4 order, my lord, the authority will not decide how the acquisition process come, whether they have received award or not. Encroachment has been done. It was found. Appeal against.
How was it found that? How do you say that it is PWD land? Please show me.
I am showing, my lord. My lord, kindly take my report, my lord. Paste.
Because your report says that it was acquired under the
Defense of India
Act, but there is no document of acquisition.
I'm
It is
showing,
only
my
a
lord.
possession certificate that you are showing.
I am showing, my lord. My lord, kindly come, my lord. Page 2, my averments on affidavit. My averments on affidavit. My lord. That I state that who is, my lord, affirming the same, my lord, the executive engineer, Mushidab. I state that after necessary inquiry from the lands record of the land acquisition department, so it is, my lord, the record we bring from the land acquisition department. Land acquisition department, Mushidabad, it reveals that in respect to subject, the LR plot number such and such, RS number such and such, under Bouda such and such, the total 32 decimal of land of 30 out of 34 was acquired in connection to Defense of India Act 6/65-66.
No document. Cannot be accepted.
Yes, my lord, it is, we are not
When you
record
could
keeper,
see
my lord.
when you could see the documents from the land acquisition department,
We have
what prevented you from filing the same before this court, along with the report?
My lord, actually, this affidavit has been affirmed by the executive engineer.
Maybe, whatever.
But my lord, the record should be, my lord, live with the, my lord, land acquisition, my lord.
Affidavit.
I do not know whether land acquisition.
Report was called for from the respondents.
But that has been collected, my lord, and this document has been 30 years old, more than 30 years old, and this document has been, my lord, taken out from the proper custody. My lord, kindly consider section 90 of the Indian Evidence Act. 30 years document and taken from the proper custody. There should not be any dispute,
The
my lord.
document should be, you are aware of section 90. Please do not make this submission.
Now, my lord,
If the
what
document
happened,
is
my lord?
produced before the court, the 30, it is
My lord,
considered.
one thing, my lord, acquisition, land acquisition department has not been made party, my lord. My lord, I am coming, my lord. My lord, I am coming. So, my lord, pursuant to my averments, I have collected the, my lord, documents which I have just annexed, my lord, at page number 4. That, my lord, in respect to
What document have you annexed, sir?
Yes, my lord, that is the, my lord, kindly consider this aspect that the land, the record is too old, from 1965-66, and he is now assailing the acquisition after.
You are claiming encroachment on those two old records.
Yes, my lord.
So you must substantiate.
Yes, my lord,
document.
whatever I collected, my lord,
This is
whatever
nothing.
I have collected, my lord.
This is nothing at all. That too are blank, total area acquired blank.
But my lord, in respect to
is this?
1147, my lord, kindly see, my lord, left hand side floor, 1147.
Who has given to whom? The position?
Position, my lord?
Given to whom? By whom? Where is that recorded? Can this be called a possession?
Yes, my lord, this document is not showing the same, my lord.
It is not showing anything at all, I'm afraid.
But my lord, it is showing, my lord, a authenticated document, a copy of the authenticated document, which is showing, my lord, in their 1965-66
during pendency of the
land has been acquired.
Where is it showing?
I am satisfying, my lord.
Anyway.
I am satisfying in another way, my lord. Kindly, my lord, take this, my lord, in the year, as per page 4, my lord, in the year 1965-66, the land of the petitioner 34 decibel has been acquired out of 32 acquired out of 34. Now, my lord, my lord had rightly pointed out, which just showed my lord, petitioner, my lord, regarding the Defence of India Act, any operation has been done shall not affect the operation taken earlier, my lord. Just my lord pointed. Now, my lord, kindly, they, Paresman are supposed to produce the appeal copy, which was filed before the DM. My lord, kindly take, I have managed to, my lord, collect the, my lord, soft copy of the appeal, which is preferred before the DM. My lord, I am
That
just.
is on record.
Yes, my lord.
That is on record, the 10-4 appeal.
Therefore, appeal petition is not on record.
Copy of the appeal petition is not. I have that.
Like appeal petition?
Yes, yes.
My lord, kindly see the appeal petition. My lord, what I have just showed to my lord, the land has been acquired in the year 65.
You have not shown, I'm sorry.
My,
sir. You have not shown.
my lord, satisfying, my lord.
A document which has been authenticated only in 2023.
Yes, my lord.
There is no other seal of the department, nothing.
No,
Cannot be, it's just a scrap of paper which has to be discarded.
My lord,
no value at all.
Actually, my lord, the main prayer of the petitioner is not challenging the acquisition process.
He doesn't need to challenge.
He is just
You have said encroacher. So please show that he is encroacher. I do not find anything to show that he is encroacher.
My lord, I am satisfying. My lord, kindly come to my lord appeal petition.
Not only that, the tribal suit is pending before the before the civil court.
Yes.
So how can you say he is encroacher before the civil court decides?
No, my lord, I'm stating, my lord, from the submission of the petitioner itself. Kindly, my lord, take page 2 of the appeal petition.
Yes.
Page 2, my lord.
Yes.
Paragraph 2.
Yes.
My lord, which I have showed just, my lord, land has been allegedly, my lord, suppose, allegedly acquired in the year 65-66. Now, my lord, kindly take, my lord, paragraph number 2, I am reading that your appellants, that means, my lord, petitioner and his, her husband, that your appellant state that the mother of the appellant number 2 gifted a dwelling house comprising in such and such land, Moja such and such, PS such and such, by way of registered Hebanama deed of gift recorded in book number such and such. My lord, kindly see the year. Kindly see the year. In the year 1991.
Yes.
So, my lord, it is admitted fact in the year 1991, the subject property which has been acquired far back in the year 60.
Because it has not been acquired. There is no document.
Yes. No, I am satisfied on the later stage, my lord. Because, my lord, it is not challenging the acquisition process. Kindly consider. He has just, my lord, challenged the 10-4 order. My lord, 10-4 order, what the DM will do? DM will, my lord, act on the basis of the record of the land acquisition department.
I want to see that record on which the DM has acted.
And one of from the report of the BLR, it is very well fully revealed.
Is that authentic? How does the BLR said that this is government land, PWD land?
On what basis? What happened, my lord? The lab acquisition has been done, my lord, far back. It is, my lord, really very difficult.
On what basis do you say that it is PWD land and it has been encroached upon?
My lord, because, my lord, by the force of these documents,
because the documents show that it is the petitioner's land.
No, my lord, this document, how the petitioner came to know that he has the land over. My lord, kindly consider this paragraph number 2.
Yes.
The petitioner is stating in the before the DA that land has been gifted by his mother Indian in the year 1991. My lord, that means land has been, my lord, suppose for the sake of argument, allegedly acquired in the year 1965-66. Then how this transfer is, my lord, valid, my lord?
Provided you can show the acquisition, not otherwise. This is an absolutely valid transfer.
I will try to bring my
Land
lord.
belongs to the mother. It has been gifted to the son. Absolutely fine.
Well, the
And it's
acquisition
private
document is
property.
there, my lord. That's why I am
Where is the acquisition
just my lord
document?
placing this.
What do you call the acquisition document? Please show me. I see a possession certificate which doesn't bear any seal, signature, given by whom, to whom, nothing recorded. It cannot be called a document at all.
That must be with the land acquisition department, but my lord,
Must be,
too old.
should be, the court will not
My lord,
consider. I will allow the writ petition. I'll quash
land
the
acquisition
entire proceedings
has to
and
be
is
made party, my lord. It is also an important
entire
fact.
section 10 proceeding has to be quashed.
My lord, kindly consider, my lord. Well,
Yes,
section.
upon consideration.
Sir, it is my humble submission, my lord, a humble prayer, my lord.
Can you come back with the acquisition documents?
I will try to bring, my lord. My lord, I will try to bring.
If you cannot, it's all in.
Try to bring, my lord. I will try to bring.
The old record, my lord.
It is too old record, my lord.
I'm trying, my lord.
There is nothing on record to show that.
Possible, my lord, then I shall.
Otherwise, it is evident that it is the petitioner's personal land.
My lord, kindly same time consider, my lord.
Consider what?
I will try
There
to.
should be something
My
before
lord,
the court to
such a
consider.
petitioner assailing the same.
Yes.
Such a later state petitioner assailing the
Petitioner is
acquisition
not
process
assailing anything.
without challenging the
Petitioner has been asked to leave the land, so he is before
I
the
will try
court.
to bring, my lord.
He is not assailing anything. It is for you to prove.
I will try to bring.
You are trying to throw him out from his own land. Yes, anything to add by the private respondent?
My lord, exception, my lord, file my kindly see.
Exception to?
By the respondent number 11, my lord.
Exception or report?
Exception to the report.
Exception to which
Another
report?
thing, my lord. Exception, my lord, by the respondent number 11.
First exception filed by
File.
him.
File.
First exception filed by you. Where is that exception?
Respondent number 11, my lord.
Exception.
Another thing, my lord, completely new thing is there.
July.
এটা তো
My lord.
আপনারা ফাইল করেছেন
আমি ফাইল করে সেটাই তো বলছি।
9 June.
কারা ফাইল করেছে
What are filed?
হ্যাঁ 9
My lord, 9 June, my lord. Yes, my lord.
Yes.
Page 12.
2023 filed by him.
When
Page,
did you file
page,
the exception?
Exception, my lord, filed by him, my lord, private respondent.
by the respondent number 11, my lord.
To the report.
Respondent number 11. Exception. এটা তো exception by the petitioner. Yes.
Page number 12, my lord. My lord, that report filed by the my lord petitioner in the my lord.
BLRO file, report.
BLR file, my lord.
কি
In the
বলছেন?
case of the my lord civil suit.
Yes, yes.
My lord, kindly see. The RS settlement, particularly in the decade of 50, the suit for plot bearing number so and so, area 34 decimal have been recorded in the name of Hanif and Derushek, son of Shukuddi Mondol, in 8 anaj equal share in Khotian number so and so, Mauja so and so. My lord, government, West Bengal government acquired the suit plot by RA case number so and so department acquired by the 32 decimal, 2 decimal were left in remain. My lord, in third paragraph, kindly see, my lord. At this point of time, no difficulties, no complicities were present, but in the final publication stage, so and so the suit plot is recorded in favor of 4 different persons. That is Derushek 5 decimal, Ekram Ali, son of Derestullah 1 decimal, Mohsin Mondol, that is husband of the husband of the petitioner 5 decimal, and Mafikul Islam proceeds on 1 decimal, and thus total area of 12 decimal which are in anomaly, by whom this record have been produced by not find out of acquisition of land, acquisition PWD government of West Bengal in RA case number 7. Thus, this computer error record is
is
unacceptable.
quietly unacceptable.
He is
That
supporting
12
me. Thank
decimal, my lord,
Does the BLLRO have any authority to give this report?
my lord, ask my lord,
hold what
in the
is
civil
acceptable,
suit, my
what
lord,
is
in
not
the civil suit, ask the BLR to file report. On that basis, my lord, report has been filed.
Does the BLLRO have any authority to hold this? It's a ridiculous report.
My lord,
BLLRO is saying the LR record is unacceptable. What authority does he have?
my lord, that case is, my lord,
It says it is acquired by the PWD.
PWD, my lord.
The state says it is acquired under the Defense of India Act. Isn't it contradictory?
My lord, that is case number is different. Different, my lord, completely different case. My lord, kindly see, my lord, on what I, my lord, kindly see.
28,
First paragraph, my lord,
59, 60.
RA case number 28 to 5960.
What does the state say?
Completely different. It is not Defense of India Act.
State says 65, 66.
Yes, my lord, that is different.
Maybe it's a part, my lord.
Completely different.
All maybe, can be, should be.
Different.
Yes.
My lord, the report,
Record.
report shows that BLR himself admit there is anomalies.
Another thing,
Shown my learned friend.
another thing, what I found while just reading the petition at page 8, the petitioner is not completely denying the acquisition process. Kindly see.
Who says I'm sold
Kindly
20 decimal acquired?
But my lord, he is disputing regarding the share. My lord, it is a factual aspect, my lord. It is my submission.
In any event, the writ petition and the proceeding goes. If you can still come back with documents.
I am trying, my lord. I'm trying.
Since I've expressed my mind,
I will try.
I can give you an opportunity to come back.
I'll try.
The entire proceeding is dehors the law itself. You can take this back. Let the state try and come back. Two acquisition proceedings have been referred to. One by the BLLRO, I do not know what authority he has, and the second by in your report. So please find out. The BLLRO says that the land has been acquired by the PWD, the land of the which the petitioner claims. So that also needs to come before the court.
I'm trying to bring the record, my lord.
There is an interim order up to 15 December.
It will be extended.
Then
You are claiming? Yes.
The land acquisition collected is not the bid part. Therefore, when all the papers lying with the land acquisition collected is the report.
Only for the papers.
It will benefit us.
Magistrate is a party.
Land acquisition.
They are seniors, they are superiors. They can only for records.
Respond number 3 kindly.
Land acquisition.
Additional district magistrate land acquisition.
Authority with the records, my lord, to collect.
Only for records.
My lord, kindly
The
direct.
superior authority can call for records.
I will communicate my lord
add more
to my lord.
parties.
But my lord, if
As
kindly,
it is,
my
there is
lord,
nothing in this.
it will.
Not necessary. The DM and the ADM can call for the records. They are parties. Give it a last try.
It will benefit us, my lord. If my lord, kindly.
The court is not here to benefit the state. Heard learned counsels for the parties. Paragraph learned counsel for the state respondents seeks accommodation to produce documents in support of the alleged acquisition of the plots in question as claimed by the state. Paragraph let the matter appear under the same heading on 19th January, sufficient time.
19th January.
19th January 2024, paragraph the interim order granted earlier is extended till 31st January 2024 or until further orders, whichever is earlier. 19th January 2024. Oh, ekdom shuruতে exception used by the petitioner to the report in the form of affidavit filed on behalf of the 8th or 11th.
No. It's an exception in response to the affidavit filed by respondent number 11.
11th respondent is taken on record.
Grateful.
Next.
Item number 6, appellate side daily list motion. Item numbers.
My lord, exception I am filing. My lord, exception I am filing.
Exception service finding.
Yes, yes, I have already served. Yes, yes, it was served. Long service. Exception was served.
Reply finding service.
This.
Three exceptions.
My lord, today is for the extension of interim order. My lord, kindly see.
My lord,
One leave.
no, let me see. Sorry. My lord, matter before lordship, the notice.
Take the microphone, please.
My lord, the notice issued by the respondents, which was.
You received copy of the exceptions?
Yes, yes, yes. My lord, the notice issued by the respondents, my lord, on 22nd March 2023. The same set of notice, which was earlier, my lord, quashed by this honorable court and settled the issue by judgment and order dated 12 May 1998. Same set of petition is before your lordship. And my lord, from the notice, my lord, you will find the instant notice is, my lord, the one Xerox copy without mentioning any name of the shop owners pasted outside the nearby shop. My lord, page 151. This is the notice, sample notice. Yes. My lord, on the basis of this notice, my lord, we have challenged the writ application before this honorable court. Now, my lord, I am coming to the notice dated 31st December 1997, which I have annexed in this writ application. My lord, you find it at page 119 to 120. In that notice, my lord, the name was mentioned of the shop owners. The sample notice I have annexed, my lord, kindly have a look. 120, just take one notice, my lord, 120. Railway plot number such and such. Bogdaidia Kharagpur was temporarily licensed out to you under license agreement. I, on behalf of the President of India, is hereby give you notice in quit to deliver a back in position of the above mentioned railway plot and restore the same to the original state on the expiry of January 19, since the said railway notice is received by the circulating law. I also hereby this particular notice was challenged before this honorable court. My lord, I have annexed the representation before. My lord will find the representation made the petitioners here. Then, my lord, the order starts from 133, and my lord, kindly page 150. The several 150. Well, the main portion of this. I am reading the order, my lord. When this matter, my lord, that time, my lord, I was also in this matter. 98. My lord, when this matter was came up, first considered Mr. Rina Maulik, the learned advocate for the respondents, submitted and stated before this that the notice dated 31st 12/1910 impugned in this petition be set aside by the court, but absolute liberty be reserved to the respondents to one again act in the matter in accordance with law and pass appropriate consequential order. Mr. Bhattacharya, the learned advocate for the petitioner, has no objection to this course being adopted. Hard upon the aforesaid side, I dispose of the writ application finally and set aside the above referred impugned order, whereby the petitioners were called upon and directed to vacate the property in question. However, absolute liberty is given to the respondents to act in the matter of seeking the recovery of possession from the petitioner from the property in question in accordance with law. Since 97 to 2023, 22nd March 2023, my lord, no notice, absolutely. And my lord, the one Xerox notice pasted outside the wall, whether tenable under the law, and the issues in the notice that was already set aside by this court in the year 1998. Can, my lord, this notice be, my lord, the maintainable in the law?
Notice?
1990, that was set aside. In accordance with law, they did not take any steps.
We are carrying on business in 1979. We are a poor shop owners. What is our position of the land, my lord? 5 foot by 5, 10 into 15, 10 by 10, 100 square feet, 150 square feet, 15 square feet. We are poor shop owners outside the railway station, not in the inside. It is absolutely outside the railway station. In front of the shop, 40-foot wide road is there.
Please show the relevant law.
My lord?
What was the indication of the court? In accordance with law, what does that really mean?
My lord, the earlier order?
Yes, it
Well,
says in accordance with law.
Law. My lord, the law, my lord, doesn't permit, my lord, this kind of notice.
What is the relevant law?
The court granted liberty to act to seek recovery of the possession in accordance with law.
Shanti. Railways Act. Shanti. Railways Act. Railways Act.
We are here licensee. We are carrying on business at the manor.
Only one permission. Let them produce one documents that they are licensed.
I'm sorry.
Only one document.
They have in their ballot the report. They have submitted. 13 petitioners are the license out in the report. They have stated that the 13 petitioners they are the licensee of this particular plot, and ballot the fourth also ballot they in respect of one ballot they did not find any papers, and others ballot they are the licensee. That is there in the report.
Let them produce one valid documents that they are the licensee.
We are the licensee, my lord. The receipt I have annexed in the application. All the petitioners
from the bar, my lord, that they are the licensee.
The license fee, the receipt.
Well, coming to it. My lord, page 37, my lord, find the, my lord, the rent we have paid since 22-23.
37.
37. Then 40. Then 41. 42.
Kindly see the, my lord, date.
Date by 42. Up to March to 23.
And my lord,
since they issued the, let me submit fast. Let me submit fast. You have every right to submit to the court.
Continue.
Well, page 43. This is about 22-23. Then, well, next 44. Munilal Patel. Then, my lord, page 48. This is the conversion charge, change of ownership. Father had died. For that, his son has applied. That is permissible under their circular. Then, my lord, 51, 50, 51, 52, 58, 59, page 60, 61. Same, my lord, 61 continuing, my lord, 63 continuing 2021. Then, my lord, 21, 22, 64. Then, my lord, page 65. This, in respect of this particular plot, in the report they have stated they did not found any document in their record. But the railway authority, they have issued the money receipt and the allotment letter, my lord, I am showing you to lordship. This particular for the plot. Page 65, my lord, page 65. This is the allotment letter. Next, my lord, the page 66. This is the allotment letter.
The writ petition, where have you stated about the plots, plot numbers?
My lord, in the cost title, my lord, you will find. Page 3.
Licensee under the respondent, no, in the averment.
License. My lord, in this page 66, my lord, find they have stated in the, my lord, the exception, my lord, the in the report, in this particular plot, they did not find any record. My lord, money receipt is 65 and 66 is allotment letter. Why this was allotted to the Judge one stall? This was allotted because the 5% quota was reserved for the military personnel, those who are died in the war. In the Bangladesh war, the person who is 5 foot by 5 foot top was allotted, but his father was died during the Bangladesh war. For that reason, this particular plot was allotted to the petitioner. Then 67 also, find the money receipts. 69, 70, 71. And then, all the allotment letters have annexed in the writ application. So they stated in their report that 13 writ petitioners, so they are the licensee, the 79 allotment letter was issued. They have paid the rent. I have shown you also the rent receipts. And in the 1997 and in the 1998, they also issued a circular for change of ownership because of the son died, and some old plot holders, they are unable to carry on business. For that reason, the railway authority issued a policy for change of ownership. One sample of the order of the change of ownership I have shown to your lordship. So, from the writ petition, your lordship found that all the British petitioners are licensed and they are carried on business. They have paid their license fees till since 22, because 22nd March 2023 notice was issued. Since the March notice was issued, from the March onwards, they have stopped receiving the rent, the license fees. And this particular plot was allotted, only some small plot of land was allotted, but construction was made from my pocket. As per their license agreement, I have to construct the shop at my own cost. So, and the 79 to till date we are carrying on business.
Where is the license agreement?
One copy license agreement is not here, because we didn't have agreement copies, sample copy.
You are referring to a license agreement.
Not license agreement. They have stated about the license agreement, but the allotment letter, I have annexed the allotment letter.
At page?
Page 94 onwards. Kindly page 87, one allotment letter. It's allotment of plot, such as 87,
Yes.
will file the name and the 79, 38, 79, and the 6 clause A, will find the bottom 6 clause A. If construction of shop-room above lot allotment is not made, 1 month. Then the question of if the payment is not made, grace period, liquidated damages, 1% will be charged. The allotee will construct his own structure as per the standard plan and specifications by the railway, and layout checked and verified by the
Now,
railway.
this agreement was for a period of 3 years.
Initially 3 years, that was the time. Time to they are taking
Where are those
the
extensions?
extension the license fees, that is the extension. That is the normal practice. That is normal practice. There is no such other extension is there. And these issues, I earlier submitted, this issue was this temporary license, in the 1997, 31st December 1997, the railway authorities issued a notice upon us, the same set of petitioner before your lordship, and we have challenged before this court, and I have shown your lordship the order that was set aside.
Liberty to file they can issue a fresh notice.
For that reason, I am submitting your lordship whether this kind of notice at all tenable in the area. This one Xerox pasted notice without mentioning any name, the shop owners.
Let us hear the railways.
Whether this kind of notice, at all maintainable in the eye of law. And we are continuing, in the railway position, and they have in the in the report they have taken one plea that Railway Act. The Railway Act 1989 has application. Whatever railway will want, they will evict the shop owners on the strength of the Railways Act 1989. This issue was came up before this honorable court, and that particular the judgment was declared per inquirium by this honorable court. I have the judgment with me. That issue has already the railway have no implications at all. A person who has constructed a shop room at his own cost and has been carrying on business since 79 to till date, and there is an option for regulation of shop. There is a circular issued by them for change of ownership, and whether the railway authorities by issuing this kind of notice, a simple Xerox pasted notice, can evict the petitioners. It is absolutely the bad in law, and it should be set aside by this honorable court.
Let us hear the railways. Yes.
My lord, my first submission is this only, my lord, that the money payment received that doesn't, my lord, create any right, my lord, regarding the license.
Letters?
Licensee, my lord, is a separate agreement in between the railway and there is a specific standard form, my lord, issued by the railway board. And whenever, my lord, they are extending the period of licensing, they are renewing this. My lord, in my case, my lord, no such agreement was there. My lord, originally they have allotted that portion of land, my lord, in the year of 1979. My lord, that doesn't mean that will continue, my lord, for a ever-ending period. My lord, nowadays, they are simply, my lord, transferred this portion of land to another. My lord, there is no such provision for inheritance of that. My lord, that may be, my lord, that portion was land, my lord, his father or his grandfather was inducted. But nowadays, they have gone, my lord. As soon as, my lord, that period expired, they will be treated as a unauthorized occupier.
Please show me the rule.
Yes, my lord, I'm coming. My lord, that is the reported judgment of since our single bench, division bench, and the Honorable Supreme Court also, my lord. My lord, their first submission is this: they are the valid licensee. My lord, where is the document that the license agreement is there? No license agreement. They have produced the one document, page 87. My lord, that was executed in the year of 1979, my lord. And my lord, kindly see what was stated in the last paragraph, my lord, of this allotment letter, page 88, my lord.
Yes.
Page 88, my lord, paragraph, my lord, F, my lord. The railway reserved the right to terminate the licensee at short notice without payment of any compensation for the structure built on the above plot.
Where is the notice?
Yes, notice they have produced, my lord. They have, which is under challenge. Yes, my lord. As because why there is no such name, my lord, in the railway record, my lord, there is no such name is there. They are simply transferred to the another part. My lord, kindly compare the name of the writ petitioner and the name in which name the money receipt was issued. Kindly compare, my lord.
Where is the law of eviction
And
in the Railways Act?
that was, my lord, issued in the year of 1979, in which name that person who was occupying at the year of 1979, they are now there, my lord.
You have
Yes, my lord. Instead of that, somebody else, my lord, they are positioning. My lord, simply that person is transferring that portion of land to the another portion by taking money. Yes, my lord.
That amounts to acquiescence.
Yes, yes. My lord, kindly see my affidavit in opposition, my lord. My report, my lord.
Where is the law for eviction of a licensee?
Law of eviction 147 is there, my lord, under the Railway Act.
Well, that is declared a par inferior.
And my lord, on that basis, at least 30 judgment of our honorable court is there, including Supreme Court and division bench judgment, my lord. I'm coming, my lord, on the judgment, my lord. Before that, my lord, kindly, my lord, allow me to place my report, my lord.
Yes. Yes.
My lord, at present, my lord, that portion of land is required for the purpose of, my lord, the Amrit Bharat station scheme, in which was declared by the railway board in the on December 2022. Total all over India, my lord, 909 station is to be developed under that scheme, and Kharagpur is the biggest, my lord. For this reason, my lord, the railway minister has come and announced that program, my lord, in the December 2022. My lord, kindly come to the paragraph 4 of my report, my lord. I am placing, my lord, few paragraphs. That the Ministry of Railway launched the Amrit Bharat station scheme in December 2022 to modernize the development of railway station of Indian Railway for passenger safety and amenities to complement the station upgrade. The Amrit Bharat station scheme will focus on widening roads adjacent to the station by removing unwanted structure. This initiative aims to enhance the accessibility and streamline traffic flow, ensuring seamless connectivity for commuters. Presently, the scheme envisages to take up total 12775 railway station for upgradation, modernization over Indian Railway, and the Kharagpur station is selected as serial number 920 therein. My lord, I have annexed that documents. My lord, kindly come to the annexure P1, my lord. Annexure, my lord, R1, my lord. Page 11, my lord. That is the policy of the government, my lord. And only, my lord, due to such unauthorized occupiers that they are not able to start this project, my lord. My lord, serial number 920, that is the Kharagpur station, my lord.
Even if it is accepted that they are unauthorized occupiers,
Yes.
you have to evict them by due process of law. That is the law.
My lord, in case of a railway, even our judgment is this. No such notice is required.
Please show me the judgment.
Yes, I am coming on the judgment. My lord, kindly come to the page 33, my lord.
Yes.
Page 33, serial number 920. That is the Kharagpur station is there. And my lord, the most biggest project is there, my lord, at Kharagpur station. As because that is the longest station. Then, my lord, kindly come to the next paragraph of my opposition report, my lord, at page 5, my lord. Paragraph 5, my lord. That according to the Railway Boards Act 905, each and every circular guideline order of the Railway Board has the statutory force. And in the instant case, the said policies of the Railway Board in the name of Amrit Bharat station scheme is not under challenge in the said writ petition.
Sure.
It is not under challenge. So, my lord, that portion is required, my lord, for development of that project, my lord. 6, my lord. I most respectfully said that the status of all petitioner in nutshell as obtained from the office record for the purpose of the proper disposal of kind consideration of this honorable court. That total 16 numbers railway plots are involved in the instant writ petition. But the status of the petitioner is not same. That the 3 numbers of petitioner being petitioner number 2, 11 or 13 claiming as licensee for the railway plot number STN 20, STN 1009 and STN 25 respectively are false and fabricated. No such document is there. The plot number STN 20 has been transferred to plot number STN 75 long before by letter number such and such dated 3/2/1988, and plot holder of plot number STN 74 is not the petitioner of this instant petitioner. No record is found for the railway plot number STN 1009 in question, and railway plot number STN 25 was terminated long before by notice dated such and such dated 31st December 1997. So the petitioner number 2, 11 or 13 claimed as licenses of plot number STN 20, STN 1009 and STN 25 respectively are purely false and fabricated, and they are entering upon the railway property without lawful authority and misuse such railway property and also refuse to leave. So they are nothing but trespasser, unauthorized occupiers over the railway land in question. Copy of the railway letter, then such and such manner, those are annexed manner. Then paragraph C, The remaining 13 numbers of railway plots are temporarily licensed long before, that is in the year of 1979, for 3 years only, in which 9 numbers of plot holders being petitioner number 3, 4, 5, 7, 8, 10, 14, 15 and 16 or their predecessors neither signed any temporary license agreement with the railway nor renewed their licenses thereafter. But the possession of the concerned plot was already handed over to the other parties without any permission of the railway by violation of the Railway Act. It was specifically stated in the license agreement that the licensee has no authority or right to transfer the impugned plot of land to any other. And 4 numbers of plot holder being petitioner number 1, 6, 9 and 12 had renewed their license in the year between 2011 to 2015 for 5 years only. But all the renewed licensing period have already been expired long before, prior to May 2020, not renewed their licenses thereafter. All those information was noticed when the survey made by the railway in the year of 2021, that as per various clauses of the usual temporary license agreement, the petitioner are also liable to vacate the occupied railway plot in question. The clause number 15 of the usual license agreement clearly state as follows. Suspension and determination of the agreement by the President. The administration shall any time and from time to time be at liberty to its absolute discretion to suspend temporarily and or terminate this agreement and all of the privileges hereby granted upon the expiration of 1 month's notice in writing of its intention so to do, being left at or sent by the registered post to the registered office address of the licensee, and notwithstanding that the licensee may have executed any work of a permanent or temporary character and incurred expenses in the execution hereof, the licensee shall not be entitled to any damages of compensation by the reasons of such termination or suspension. My lord, page 88, my lord, that paragraph is also there, my lord.
So it is notice at the registered address of each of the persons.
My lord, how they have sought the notice, my lord, for this reason I have read, my lord, that paragraph 5, my lord. I have stated in paragraph 6 that what is the status of the present petitioner, that the out of 16 petitioner, 14, my lord,
Then if they are unauthorized occupiers, they are entitled to
yes.
notice.
So, my lord, how the railway will serve upon them? Because who are the present petitioner? And according to the railway, my lord, who was the allotee, they are the completely different person.
The railway has received the fees from.
Compare, my lord, kindly compare the name, my lord. Railway, my lord, is responsible for those person who was railway, my lord, given the land.
But they can receive the fees from anyone.
No, my lord. No, kindly compare, my lord. My lord, for this reason, my lord, I have specifically stated, given the writ petitioner number, my lord.
Maybe.
My lord, kindly compare, my lord, herein now. Kindly compare.
I understand. If they are separate, different persons.
Yes, several different persons. So, my lord.
You have received the fees from them?
No, my lord. Received, my lord, from the original landholders in the name. But, my lord, who are the writ petitioner here? They are the completely different person. And, my lord, what is happening there? At the time of, my lord, the payment of fees, the concerned authority in the cash counter, they are not the authorized person to, my lord, scrutinize the whether they are the
railway's internal problem.
simply, my lord, they are offering the money and they are accepting by issuing this money receipt. But that doesn't, my lord, not that they are the authorized licensee. Authorized licensee, they should be possessed, my lord, the valid license commercial agreement. That is not there, my lord. And my lord, then, my lord.
Next, yes.
Then, my lord, kindly come to the paragraph 7, my lord.
Yes.
Notice being number such and such dated 22/3/2023 has been issued against the petitioners for requirement of the railway lands for own station development project under the policy for Amrit Bharat Station Scheme and the Railway Board for passenger amenities in the greatest interest of the general public. My lord, cause for a moment, my lord. Suppose in the notice, no name is there. But my lord, they are received that and they are challenged that. Yes.
It was pasted on
Yes, my lord, according to the CPC also.
That receipt?
Is my lord, if my lord, the original person is not there, so what will the my lord, for this reason they are pasted there?
That is not the law at all, sir. Next.
Paragraph 8, my lord. Kindly come to the paragraph 8, my lord, page 6. That out of 16 petitioners of the instant writ petition, 3 petitioners are purely trespassers and unauthorized occupiers over the railway land in question, and 9 other petitioners or their predecessors have not signed any license agreement with the railway. So how the railway will serve the notice, man? Railway has the record regarding the original person in whose favor land was, my lord, given, my lord. Those person is now there, not there. Have not renewed their temporary license agreement but handed over possession of their plots or to the other without any permission, intimation to the respondents, and remaining 4 petitioners had renewed their license in the year of 2011 to 2015 for 5 years only.
Repetition of the earlier paragraphs.
Yes, my lord?
Repetition of the earlier paragraphs. This has been
Yes,
stated in
yes,
earlier
yes.
paragraphs.
So, my lord, that they have all the petitioner, they had no valid license and no, my lord, the land agreement was executed in his favor forever, my lord, since from 1979. And my lord, kindly see the page 56.
Of your report?
Page 54, my lord.
54?
Yes.
Yes.
Page 54, my lord. I am not annexing all, my lord. All are same, my lord. That was, my lord, Krishna Gopal Das, plot 20, Kharagpur station area. Subject, temporary permission of plot 20. My lord, that is always for temporary. As because, my lord, when, my lord, the railway for the development purpose plot is required, they have to hand it over that. That is also, my lord, stated in the page 88, my lord. Your representation dated such and such, in terms of your representation dated such and such, this is to inform you that you are permitted to continue your business of plot number 20 instead of plot number 74, which is under unauthorized occupation. In this connection, you are also note that you will have to shift your shop from 74 as soon as the same is free from unauthorized encroachment. You may construct purely temporary structure on plot number 20 where you are conducting business at present. My lord, it is for all the, my lord, purpose is for temporary. Then, my lord, kindly come to the page 56.
Yes.
My lord, whereas, my lord, in that is in English written, my lord, in just, my lord, page 56, my lord.
Yes, page
Type
56.
copy is there, my lord.
57 is the type copy.
Page 7, my lord. My lord, last paragraph, whereas the licensee SUVRA Maiti hereby permitted the licensee from the 19th day 2011 and SUVRA Maiti occupy the area in the original drawing such and such. My lord, that is for, my lord, the 5 years, my lord. No, no. And my lord, there is no such provision for automatic renewal, my lord. Yes. My lord, kindly come to the page 63, my lord. And my lord, kindly compare the paragraph 6. They have unauthorizedly transferred to another person, and page 63, my lord, my lord, that is type copy, my lord. The administration shall anytime and from time to time be at liberty to its absolute discretion to suspend temporarily or terminate this agreement, and shall of a privilege hereby granted upon the expiration of one office address of the licensee, and notwithstanding that the licensee may have executed the work of a permanent or temporary character and incurred expense in the execution, herein the licensee shall not be entitled to any damages or compensation for the reasons of termination or suspension. And my lord, there is no such provision for transfer, my lord, that license to any other person. Arbitration clause. My lord, there is no such provision in the agreement to transfer that. And my lord, page 65, that arbitration clause is there.
Arbitration is with regard to application of any of the terms of the agreement.
Regarding the agreement, man.
He is only on the notice.
So, my lord, kindly, in the event of any difference or dispute in any time arising between the administration and the said licensee as to the meaning or to the application of any of the terms of the agreement, or as to the right, duties, and objections. Yes, my lord. Kindly consider the word right, duties, and obligation. That all are involved.
There is a provision for arbitration, the writ court can take up matters.
My lord, my lord, my lord, it is, my lord, the settled law nowadays that if there is any arbitration clause in the agreement, in that case, my lord, the writ petition is not maintainable.
It is no longer res integra.
Yes, my lord.
There are several judgments which say that the writ court can intervene even if there is an arbitration clause.
My lord, first of all, they have to, my lord.
Please show me the law of eviction under the regulation.
Yes, my lord. Kindly come to the page 68, change of ownership. They have to, my lord, show some documents that they have any right to occupy the railway land. So
they do not
they have no locus standi to file any writ petition, my lord.
that is accepted. Even an unauthorized occupier.
Not accepted, my lord. For this reason, I have specifically stated in paragraph 6 and its subparagraph.
The law says that an unauthorized occupier has to be evicted by due course of law.
Yes, my lord.
Where is the notice
Yes.
of each of the unauthorized occupiers?
Yes. I am coming on that, my lord. I shall show, my lord, the judgment. Kindly see the page 68, my lord. Change of ownership. Again, in terms of such and such, Ministry of Railway dated such and such, the regularization of charge of ownership for 5 years is subject to payment of outstanding payment by a party with 70% interest. Security deposit, occupation fee shall be collected. Respect of the ownership of my lord, 31. Any dispute or differences is raised arises in further in respect of change of ownership, the shop plot in question shall be taken back and kept under custody of the railway administration till finalization of the same. My lord, they have failed to produce any valid documents. And my lord, there is no such provision to transfer that plot of land to any person, my lord. আছে আছে আমার কাছে গুচ্ছ
Please show me the eviction law.
Yes.
Nothing else is required in this case. Even accepting the petitioners to be
Yes.
unauthorized occupiers.
My lord, just now, my lord, I have one copy, my lord. After reading, my lord, I shall hand over. My lord, that is, my lord, that was passed on 27th of October 2017. Ramchandra Mullik. My lord, that is, my lord. Passed by the Honorable Justice Devanshu Bosak, my lord. I am placing, my lord, that judgment. My lord, I am reading from page 3, my lord. Power to evict a trespasser is recognized under section 147 of the Act of 1989. Such power came for consideration before this honorable court in G. Falgunas. There, the writ petitioner were seeking a direction upon the railway authorities not to evict them without invoking the provision of public premises, Unauthorized Occupants Act 1971. Such plea was negated. The railway authorities were found to be entitled to evict the trespasser without the Act of 1971 by exercising power under section 147 of the Act of 1989. Such position in law was followed in Imran Ahmed. These two decisions were taken into consideration in Dhurjyoti Prasad Das SUVRA, and the court found the railway authorities to be entitled to evict trespassers by exercising power under section 147 of the Act of 1989. In a different factual context, the appeal court in Eastern Railway found that the railway authorities are entitled to evict trespasser forcibly also. In the present case, the railway authorities contend that the land in question occupied by the petitioners is required for the purpose of expansion of Grand Quad line passing through such area. Such a project is in public interest. The petitioner does not have any subsisting legal right to occupy the property of the railway authorities. The power of the railway to evict the trespassers exercising the provision of section 147 of the Act of 1989 are well recognized. The railway authorities have invoked such provision in the process of evicting the petitioner. In such factual matrix, no interference is called for by the writ court and the writ petition is dismissed.
Doesn't talk about notice.
Yes, my lord.
Doesn't talk about notice.
Yes.
That no notice is necessary, it's not.
Yes. In no notice is also required.
Where is that stated? No notice is.
And my lord, question 147.
Yes, 147.
147, my lord, 147 doesn't show regarding the notice. My lord, simply while executing the power under section 147, they can evict.
147 says if the petitioner misuses or refuses to leave.
Yes, in my case also, they are the unauthorized occupier.
147 is not really applicable. Anyway, next.
My lord, this judgment is already held by this court as par interium. This is a reported.
No, my lord, that three judges bench hold that.
No.
Three judges bench.
This
Three judges bench.
Ramchandra Nayak and other my lord, the judgment.
Yes,
My
yes,
lord,
I'm
referred
coming,
to
man.
the recent judgment of this court, my lord, in 2022, passed by the Honorable Justice Subhasachi Bodcher.
Yes.
It has been
That was
declared par interium and referred before the three judges bench.
Before the
this judgment, my lord,
does not have hold that is
any
valid.
force at all. I have in my
So, my lord,
Show me the judgment of the three judges bench also.
well, just now, my lord, I am not with the three judges bench. But my lord, I have two judges bench and the other judgment is also with us.
lease is pending, probably. So, for my instructions,
No, my lord,
lease is pending.
that was, my lord, hold that is 147 and that judgment is valid.
If the subsequent judgment says per inturium, then I.
No, subsequent, that matter was referred after the judgment of Justice Sobhusachi. Just at present, my lord, not with me. But my lord, I know my lord that. My lord, next judgment is my lord, that is Subrata GHOSH. My lord, considering the various judgment of the Honorable Supreme Court and our High Courts, my lord, and those judgment also, Dhurjyoti Prasad and this judgment, my lord.
My lord, my lord, the justice.
Please let him complete.
My lord, a license is subject to the revocation of such license can be evicted. The eviction, however, has to be in due course of law. By due course of law, one understands that the process by which a person who has entered into the premises lawfully as a licensee and upon termination of such licensee stand as a trespasser is evicted by a method recognized by law. If there is a statute governing the process of eviction, then due course of law will mean that possession can be recovered by taking recourse of such statute. According to the petitioner, the Act of 1971 operates in this field and the section 147 of the Act of 1989 has no manner of application. The interplay between section 147 of the Act of 1989 and the provision of the Act of 1971 has been considered in G. Falguna and Dhurjyoti Prasad Das. As noted above, there is no material on record to a view contrary to those expressed therein. Moreover, the courts has consistently allowed eviction of licenses as that of the petitioner to be evicted from railway property under section 147 of the Act of 1989. Section 147 of the Act of 1989 is a due course of law for evicting a trespasser. S.L. Kapoor, Basidev theory and Prakash Ratan Sinha's case have held that where the statute does not expressly oust the applicability of the principle of natural justice, then the action taken by the authorities must adhere to such principle at the pain of such action being declared as null and void, and for no adherence of such principle. It is settled law that principle of natural justice should not be mindlessly applied to strike down every administrative action when no fruitful purpose would be served by affording the so-called aggrieved person with a right of audience. In the present case, the petitioner was issued a notice of termination requiring the petitioner to vacate the subject plot. The notice is dated September 10, 2014. The petitioner had 48 hours to react such notice. The petitioner made a representation with regard thereto on September 11, 2014. Principle of natural justice do not mean that the aggrieved person has to be given a right of audience. Allowing the aggrieved person to submit a representation to sufficient compliance of the principle of natural justice in these facts of the present case, the representation dated September 11, 2015 contains nothing which allows any reasonable person to take a view contrary to the railway with regard to the eviction of the petitioner.
So this supports the petitioner's case. A notice, then an opportunity of representation.
My lord, earlier paragraph stated, my lord, by simply, my lord, relying on the basis of 147, they can evict it. That is, my lord, the settled law also holds.
Natural justice.
That is also hold, my lord. In fact of the present case, I am not in a position to find that the action taken by the railway stand visited by the breach of principle of natural justice. In such circumstances, the challenge in the present writ petition fails. And my lord, the next, that is the Dhurjyoti Prasad, that was passed by the Honorable Justice Sanjeev Banerjee.
Please give me copy of the judgments and
Yes, certainly, my lord. Certainly. I shall also give the copy to my learned friend also. In Dhurjyoti Prasad, my lord, section 147 quoted in the judgment also, my lord. My lord, I am not.
Will you come back day after tomorrow with all the judgments? That's the only part left because it has been heard substantially. If you want to refer judgments, you can by day after tomorrow.
Yes. Hello, day after tomorrow, I have some problem. Hello, next Tuesday.
Next Tuesday. Because I want to dispose it of because I've heard.
My lord, I am ready to. My lord, I am ready with the matter. My lord,
Because my lord, both the parties, my lord, exchange their affidavits.
That's why I want to dispose it of. Heard learned counsels for the parties. Paragraph, let the matter appear under the same heading for further consideration on next week.
Well,
13th, 1-3.
13th of this month.
December.
my lord, interim order be extended. My lord, I have filed the extension of interim order, my lord, within time.
My lord, may I submit one thing? My lord, let the position may be same, my lord. I think, my lord, within 13 days.
Let there be judicial order.
They will not be evicted.
My lord,
When was it? It was extended till?
my lord, 30th November.
Let it be extended till a limit.
That is, my lord, expired long back ago. My lord,
Long
they
back
ought
ago.
to have come, my lord, within that period.
Within that period, I filed. We have mentioned twice.
The interim order granted earlier is extended till 21st December or until further orders, comma, whichever is done.
Public.
21st December.
আমাকে দাও কেন?
হ্যাঁ, হ্যাঁ,
আমি জানো তো আমার মাথার চ্যাপ্টারে কাজ করছে, অন্য কোর্টে মামলা।
Next two items.
নামটা দিয়ে দাও।
Same, next two items. Same.
7 and 8.
You are appearing in next two items also?
এই চিন্ময় পাল তো পরে দুটোই সেম তো সেটাই।
Same.
সেম নামটা দিয়ে দাও।
6, 7, 8, same order.
6, 7, 8.
কোথায় পড়ে গেছে?
Appellate side daily list, item number 9, new motion.
Lordship, I'm for the petitioner. Lordship, I'm praying for Passover.
Passover is not possible in this court. Respondents? After vacation, madam. None appears for the respondents. Paragraph on prayer of the petitioner, the matter is adjourned. Paragraph, let the matter appear under the same heading on 19th January.
Item number 10.
10, my lord, I am for the petitioner, my lord.
Yes, you are the petitioner.
My lord, I am for the petitioner, my lord.
Mr. Nag for the state. Mr. Orko Kumar Nag.
My lord, he was appearing for the state. My lord, the matter is that, my lord, the petitioner being a company was the owner of the JCB machine, my lord. My lord, the allegation was that, my lord, he was lifting moram from the forest land. As such, my lord, the JCB machine was confiscated, my lord. My lord, with regard to that, my lord, a report was filed. If your lordships kindly consider, my lord, page.
It is an order of the chief conservator of forests that you have challenged.
That I have challenged, my lord, pursuant to
Say it has to go before the civil court.
pursuant to an order passed by your lordship, my lord, to consider the representation, my lord, at the, my lord, by taking into account the report of the BRO, my lord, that is at page 31, my lord. Your lordship,
But who is the appellate authority?
my lord, the
Lord, appellate authority, my lord, already consider it, but lordship directed it, page 31, lordship kindly consider. My lord, there it was decided that the land is the Rayati land. But my lord, without considering that part, lordship kindly consider page 37. My lord, the chief conservator of forest, my lord, Central Circle, Government of West Bengal, Durgapur, my lord, he is the appellate authority. Without considering, my lord, that part, my lord, he has considered.
Yes, but this order is appealable.
My lord, the chief conservator of forest is the appellate authority. Earlier order was passed by my lord, divisional forest.
Whether the land is Rayati land or not cannot be decided by a writ court.
But lordship kindly consider my lord order.
Please, where is the order?
Lordship
Page
kindly consider page 34.
Yes, where has
My
the
lord,
court held?
my lord, page 35, lordship kindly consider, my lord, second para. Upon considering the submission made on behalf of the parties, the writ petition is disposed of directing the chief conservator of forest Central
circle,
Government of West Bengal, being the second respondent herein, to take a decision in the appeal pending before him in terms of the report of the block land and land owner officer Vishnupur, submitted on 16th August 2022, and upon affording reasonable opportunity of hearing to the parties, to the petitioner, if required within a period of 1 month from the date of communication of the order. That was the order of my lord. And accordingly, my lord, that BLRO report, lord, there is no reflection in the said order.
consider reflection.
That part has not at all been taken into account while disposing of this appeal. Lord, what I am on, lordship may refer back it to the same, my lord, by with that direction, my lord, to comply with the earlier order passed by.
For a reconsider, but today
Fine.
the respondents are not there. I do not find them.
In earlier occasions, two occasions, no one appeared.
No, Mr. Nag appeared, I find, for the record.
Before that, no one appeared.
So that there was a change of counsels.
He has not changed.
No.
He has not changed. এটাতে চেঞ্জ ছিল তারপরে
I'll give you a short date and I'll record that it will be taken up for hearing even in absence of the respondents. None appears for the respondents. Stop, no accommodation is sought. Paragraph, let the matter appear under the same heading on 14 December, next Thursday. Paragraph, it is made clear that the matter may be taken up for consideration on the adjourned date, even in absence of the respondents. Short matter can be disposed of.
Item number 11, appellate side daily list.
11 is my application, my lord. We've challenged an action.
So there is appearing.
Yes, ma'am.
We've challenged an action under the West Bengal Acquisition and Requisition Act, my lord. Now that act has been repealed, and this step, my lord, would have to be set aside. On the last occasion, the state had, my lord, filed a status report and had served it on us. I'm not pushing my matter. I'm in some other difficulty, my lord. The document that have been made over to me is otherwise illegible. There are certain annexures to the status report, my lord, which has been made over. Those are otherwise, my lord, undecipherable. So I was only praying if they could give us a more legible copy of the annexures forming the part of the status report, we could come by way of an opposition in the nature of an exception, because we wish to file so.
Some of the documents are quite illegible.
Which is what we haven't been able to decipher. So unless we decipher them, my lord, we can't really. So if they want to, because I understand these are also slightly old documents.
These documents are not legible at all. Even the court cannot go through them.
I will
Please file the clear, more legible copies.
And if they can serve us a copy in the meanwhile.
give me some time, Mala.
Lordship will also, my lord, record that I want to file an exception to the objection.
And it appears that the annexures appended to the status report submitted by the state respondents are not legible. The state respondents are directed to file legible copies of such annexures before this court by the adjourned date, and also serve a copy of the same to learned counsel for the petitioner. Paragraph, on prayer of the petitioner, liberty is granted to use an exception to the status report. After vacation,
Lordship keeps it in January, because I don't think they'll be able to 22nd. They'd come and take an adjournment.
let the matter appear under the same heading on 17 January.
17 January.
So they please hand over a copy. Of the intent.
Lordship, may I pray for one indulgence, my lord? In case, because I understand these are very old documents, in case they're unable to make over a copy, would it be your lordship's pleasure to direct them to bring the originals on the returnable date before this court? They may not have to serve it to me.
So they give it a try.
I'm deeply obliged.
Item number 12, question for the petition. Lordship, last occasion, Lordship has directed me to serve copy to the West Bengal Highway authorities. I have served, Lordship. The matter pertains to that petitioner is the absolute owner by virtue of a sale deed, and he is a recorded owner. His name has been recorded before the concerned BLLRO. Thereafter, an acquisition process may be initiated. Thereafter, Lordship, what is I'm on? There is an impugned order passed by the SDO. I'm straightway come to the point. Page number 70, annexure P11. That is the notice issued under section 3 of the West Bengal Public Land Eviction Unauthorized Occupant Act 1962. On the next page, Lordship, I have attended the hearing and submitted written objection thereto. Subsequently, they have filed a cryptic report, Lordship, at page number 74, annexure P13. Subject eviction of unauthorized occupant under section 1 of the section 4 of the West Bengal Public Land Eviction Unauthorized Occupant Act 1962, without any assigning any reason, firstly. Secondly, Lordship, this order cannot be passed by the SDO, Lordship. It's a absolute contrary to the act itself. Lordship, I'm handing over the copy of the act to your lordship. Lordship, first in the definition clause, section 2, subsection 7, public land. What are the public land? Public land means any land belong to or taken by lease the state government, a local authority, a government company or corporation owned or controlled by the central or state government, and include any land requisitioned or behalf of the state government, but does not include government road or highway within the meaning of the Bengal Highway Act 1925 or any other law for the time being act in force in the subject. So, Lordship, this is a highway for the acquisition for the purpose of highway. So this notice cannot be issued under this act.
This is a highway.
This is a highway, Kalyani Expressway. For that purpose, acquisition has been done. It's absolutely contrary to the act itself. So notice under section 3 and 4 cannot be issued. That is my specific prayer in the writ petition. Moreover, Lordship, I am the owner of portion of 2 Dag number 168 and 169. After getting the notice from under section 3 of the 1962 Act, I made an RTI application before the authority concerned. They have sent me the award copy and the notification. It is reflected from the award itself. They have given me some compensation amount for the part of Dag number 169. But not for 168. They have not issued a single penny for that.
Where is the document?
Lordship. That is in page number 67. Serial number at the bottom, serial number 184, Ramkumar De. Some amount has been allotted in his name for Dag number 1, plot number 169, page number 67. This is the copy of the award in reply. Lordship.
He is the petitioner.
He is the petitioner. Ramkumar De. But for plot number 168, nothing has been awarded till date. And no copy of the award has been sent to us. Even section 9 of the 1894 Act has not been complied with. And my first submission, this notice under section 4 of the 1962 Act cannot be issued by the SDO in any manner, because it absolutely contradict to the act itself. Because the matter relating to the highway.
That in this matter, a report in the form of affidavit be necessary.
A report? Let him come back with the report. Please consider these points.
Yes,
We
but
say it's highway.
I have seen, madam.
So it has to
If
go.
highway, madam, that notice should go. And according to the provision of law.
Let him come back with the report.
And Lordship, kindly give me liberty to file an exception to the report.
Yes, he to public.
Learned counsel for the petitioner submits that though the plot in dispute is the Kalyani Highway, notice under the West Bengal public land within bracket eviction of unauthorized occupants bracket close Act 1962 has been issued against him, which is not tenable in law. Stop. Also,
no notice has been served, Lordship, under section 9 of the 1894 Act, and no compensation has been awarded for the plot number 168. 3 points.
No compensation has been awarded to the petitioner in respect of plot number 168 in lieu of the alleged acquisition of the said plot. Paragraph, learned counsel for the state respondents seeks to submit a report in the form of affidavit in this regard. Paragraph, on prayer of the petitioner, liberty is granted to use an exception to the report. Paragraph, let the matter appear under the same heading on 19th January.
Deeply obliged. 19th.
18.
Next.
Mentioned matters. Combined monthly list item number 487.
This is my application, my lord.
Daily list item number 487.
My lord, I am for the
Activity
West Bengal
service.
Mineral Development and Trading Corporation, my lord, led by Mr. Saha.
Here is the supplementary affidavit, my lord. I am filing, my lord.
State.
I am for this.
Now, kindly see my lord's order. Earlier occasion passed.
Supplementary affidavit today.
Yes, also.
Have you served?
Yes, sir.
Just now, my lord.
Where is the supplementary?
Only 2 grounds I have taken in the supplementary affidavit, my lord. My lord, kindly see page 40, my lord. Your lordship's order, my lord. Page 40. Yes, my lord. The lease,
Yes.
the mining lease was granted in favor of the petitioner and it was rejected on some grounds, my lord. That has been challenged before this honorable court. My lord was pleased to set aside that order. Further directed the authority to consider afresh. Yes, yes, yes. And thereafter, my lord, after communication, the said order, my lord, kindly see the last operative portion of the rejection order, my lord, page 49. Paragraph 4. Page 49, paragraph 4.
Yes.
Therefore, it is ordered that the representation dated 19 April 2022 filed by the applicant in terms of the order of the Honorable High Court first is considered and rejected for the sake of government interest and observing the willful delay from the part of the petitioner to submitting bank guarantee and lease deed. My lord, the practice of the office is now, my lord, earlier occasion in the when the 2002 rules was in force, the department asking from the petitioner or the lessee to submit the draft deed, and after approval of the draft deed, it has to be finalized, and then final lease has to be submitted in the proper format, and thereafter it has been executed. But my lord, nowadays, my lord, after the 2016 rules comes, my lord, they are asking the petitioners and others lessee to submit the bank guarantee along with my lord non-judicial stamp and other A4 or legal paper, and they are printing the deed from their department, my lord. My lord, kindly see the supplementary affidavit. I have already taken this point, my lord. Not only that, here they are rejected that I have not submitted the draft deed. And I have also annexed the earlier, my lord, document. And the bank guarantee issue, my lord, under the rule 2016, my lord, sub-rule 18 says, my lord, financial assurance has to be submitted by the lessee, shall submit the financial assurance to the official authorized by the state government in this behalf before execution. So, my lord, my lease deed till date is pending for execution. Before execution, I have to submit. Therefore, the delay of submission of final lease deed or is, my lord, totally baseless, my non-application of mine, my lord. Kindly see, my lord, the rule, my lord.
Let us hear the authority.
Yes, my lord. That is the order, my lord. If your lordship will see the order, you challenge the order. That is on perusal of the materials on record and other things, my lord, that is 69.
না এটা তো অন্য ম্যাটারটা দাদা
হ্যাঁ?
ওটা তো এটা কোনটা 87 তো আপনার নাসিম আলম
শিবালম,
হ্যাঁ ওটা আলাদা matter, ওটা পরেরটা
ওই জন্য মিস হচ্ছে।
সুভাষ রিটটা দেন না দাদা রিটটা দেন
গিট আমার কাছে নেই।
আমি দেবো রিটটা
দাদা পেয়ে যান।
নেন আমারটা নেন
My lord, I have one report, my lord. Your lordship will see. একটু দিন না। That is inspection, my lord.
Have you received a copy of the report?
Just now, my lord.
Do you want to go through this and come back?
Totally pure question of law, my lord. My lord, the delay of submission of final lease deed and financial assurance, there is a specific guideline under the statute.
Have you explained the delay before the authority? There is action upon you.
My lord, there is not necessary, my lord. My lord, kindly see rule
Please come
18.
to page 42, the earlier judgment of this court. The petitioner ought to be given an opportunity to approach the competent authority and explain the delay caused in complying with the terms of the grant order.
That has been already.
There is the document showing, explaining the delay. Please show me.
Yes, my lord. The
Because that is one. of the
yes.
expenses.
Yes. Kindly see, my lord, the page 32, my lord. The delay submission of environmental clearance. That has been already submitted before the authority. Page 32, my lord, of the writ application.
Where is your explanation of delay?
Earlier occasion, my lord, they have rejected.
But earlier occasion, after in compliance with the order of this court, you were asked to file a fresh representation explaining the delay. Where is that representation?
Earlier occasion, they have rejected on the ground of delay submission of environment clearance, my lord. That has been already annexed, my lord. We have.
Please come to page 42, the order.
I have seen, my lord, that order, my lord, already seen, my lord.
Last two lines of the first paragraph, page 3, internal page 3 of the order.
The order to cheat it. Here.
Where is your representation pursuant to this order?
In the instant matter which is represented, SUVRA received additional document for the assembly election. The said order receipt of the additional magistrate
Is clear of consideration.
So without hearing the applicant and the absence of any record of the detailed hearing conducted, in this writ application that has not been annexed, my lord.
Please come back with the document. If there is no such representation, the authority has whatever the authority has done. is done.
My lord, kindly.
You were specifically asked to explain the delay caused in complying with the terms of the grant order.
Earlier occasion, my lord, the grant order was issued to submit the environment clearance within the stipulated time. That has been challenged before this honorable court.
That part is over, sir.
That part is over.
This is
Yes.
a fresh order.
পার্টটা পড়ো না। এই পার্টটা পড়ো না। ফার্স্ট প্যারাগ্রাফটা পড়ো না।
Internal page 3, first paragraph. There was a specific direction.
Explain the delay caused
Have you
in
complied?
complying with the terms of the grant order.
My lord,
Fresh hearing was taken, my lord. On that basis, my
Is your
lord. The
representative.
record is not with me at just now, my lord. I have to take instruction from the authority.
fourth paragraph টা পড়ো, এই fourth paragraph টা পড়ো। তুমি এটা করেছো কি করো?
Writ petition fails only on this ground.
Compare with the fresh prayer, reconciliation, reduce.
Fresh prayer করেছো না?
হ্যাঁ, একটা প্রেয়ার করেছিল, অ্যাডভোকেট করেছিল। একটা প্রেয়ার করেছিল অ্যাডভোকেট। এক সেকেন্ড।
To obtain an order from a court and then do not comply with it. Sir.
Includes within a photocopy of the certificate copy of the solemn order appeal passed by his lordship. This is for your kind the district magistrate as stated above. Kindly see intimation and order of compliance, solemn order, the advocate later only I have annexed.
Because it is recorded in the order impugned
Yeah.
that you have not explained the delay. That is one of the grounds for rejection. And rightly so. You have not explained the delay.
Kindly see page 44, the advocate already submitted the documents along with the honorable court's order, my lord.
আমাকে তো প্রেয়ার করতে বলেছে।
This is communication.
This
of
is
the
the only
order.
communication.
But where is the fresh representation stating all these things?
No, my lord.
Dismiss it on this ground itself. I'm sorry.
My lord, kindly,
The order has not been complied with.
my lord, kindly see supplementary
That's
affidavit.
very
I have taken some point in the supplementary affidavit, my lord.
But this is primarily, this needs to be addressed, isn't it?
Yes, madam.
You have not complied with the direction of this.
Kindly see the supplementary affidavit, my lord. Some ground was not. After the enactment of West Bengal Minerals Concession Rule 2016, District Mineral Authority, District Purbadan has adopted the new practice procedure of
Now that is a
preparing
different issue.
the issue. Yes,
It's a different issue.
but my lord, the repentation I
Compliance, explaining the delay.
presently not with me.
Direction of the court.
Yes, yes.
Will you be able to come back with such a document or I have to otherwise?
Kindly adjourn it for some time, my lord. I have to take it. Now, whether they have already applied or not,
Have you filed such a document at all?
I have to take instruction, my lord. করেনি মনে হচ্ছে নাকি? না না, এটা তো অর্ডারটা করেনি মনে হচ্ছে। এটা কি? হুম।
It is, please come to page 48. The order passed on 20th May 2022.
Yes.
In the representation, the petitioner did not make any representation indicating the cause of delay.
Yes, my lord. Causing delay to submit the bank guarantee, my lord.
That was the direction on you.
Because my lord,
Court.
earlier occasion that record not bring
Spoken about that earlier.
before your lordship, my lord.
Earlier occasion is over.
Yes, my
Then
lord.
you came before this court, you were directed to file a fresh representation explaining the delay. You have not done.
My submission is that, my lord, the delay submission of bank guarantee, they cannot say because the rule says that at any time I can submit the bank guarantee before execution.
Complied with the direction of the.
So, my lord, I am praying before your lordship to give some times, my lord. I have to take instruction, my lord. Whether
Success, please withdraw the writ petition.
liberty to file afresh, my lord.
Afresh, no question of afresh. You cannot change your representation now. You are left with no remedy. The representation cannot be changed now, cannot be improved.
Yes, yes. No, my lord, I have no documents to show before your lordship at this stage.
I have to dismiss on this ground itself.
Yes, my lord.
That's why I'm granting you an opportunity to withdraw,
Okay, withdraw.
isn't it?
Yes, yes.
Because it is recorded in the order also.
Yes,
that you
yes,
have
yes.
not complied with it.
Earlier occasion, they.
I did not record this in the order, that will only go against you.
No, document তো নেই।
Supplementary affidavit submitted by the petitioner
Documentary file করেনি আমি।
and brief case history submitted on behalf of the state respondents are taken on record. Paragraph. Learned counsel for the. petitioner, to learned counsel. But the petitioner does not intend to proceed with the matter any further. Paragraph in view of the above, the petition being WP satisfied is dismissed for non-prosecution. There shall, however, be no arrest to cause surgeon set by group sector.
Appellate side daily list. Mention matters item number 488.
I appear for the petitioner, my lord.
My lord, in item number 488, my lord, I appear for the West Bengal Mineral Development Corporation along with Mr. Sanjay Saha. My
Yes,
lord,
yes.
my lord, I received the brief, my lord, just now in court, my lord. So, my lord,
I have
my lord,
by hand, my lord,
kindly
already.
regularize the appointment of myself
Yes, sir.
and Mr. Sanjay Saha, my lord, in my lord's order, my.
State,
My lord,
There is the service upon the authority.
my lord, state is the only answering respondent in this matter, my lord.
The mineral development.
yes, my lord.
Yes, my lord.
Service.
Respondent number 3, my lord.
Service on mineral development. I cannot regularize your appointment unless it is served upon the authority.
Well, just now in court, it
I have
has been served to.
I have served a copy.
How can you serve to the council? You have to serve the authority.
My lord, no, my lord.
Shortcut to this, sir.
Not necessary to serve to the state, my lord. Only the answering respondent is state, my lord.
Will you
Expunge করে দাও
will you delete the name?
expunge করো
Yes, my lord.
You expunge. Not necessary.
Not necessary, my lord, because the long-term mining lease has been issued in the year 2002. The Mineral Development Corporation has been got the power 2021, my lord.
Yes.
For that reason, my lord, my lord was pleased to earlier occasion pass an order, my lord, to the Secretary, Commerce and Industry.
So let me expunge the name.
Yes.
Yes, my lord.
It has to be served upon the authority. If no one appears, then
Okay,
you
madam.
can regularize appointment. Not directly upon learned counsel. Yes, what is the matter about?
Kindly see your lordship's order, my lord. Kindly see page 49. The petitioner contends that pursuant to an application for grant of lease, the petitioner was granted a grant order by the concerned authority 13 November 2005. No need was released deed toward execution in favor of the petitioner. Since then, it is submitted on behalf of the petitioner that the grant order issued in favor of the petitioner is protected under Rule 61 and 34 of 2021. The petitioner submitted representation before the concerned authority in the regard on July 3rd, 21. Still pending. While kindly say operative personnel upon consideration the submission made on behalf of the parties, it was disposed of directing second respondent. Dispose of the representation submitted by the petitioner in taking into consideration Rule 61 and 34 of West Bengal Mining, Transportation, Storage and Sales Rule 2021 within a period of 2 months from the date of consideration. My lord, after communication that order, my lord, a representation has been made by the petitioner before the authority. The date of hearing was fixed. On that day, some necessary documents asked from the petitioner, my lord, by the authority. Because this old matter, my lord, from 2025, some documents was misplaced from the department. And kindly see page 57, my lord. Next date was also fixed by the authority on 13th May 2022 at 2:30 p.m. before the assistant secretary.
You submitted the documents.
Yes, my lord.
Yes.
57, the office copy for receiving the order. Then, my lord, the assistant secretary issued the rejection order with some kindly see page 69, my lord. As per GO, the following documents are required to be submitted within 6 months. Treasury challan rupees 500, treasury challan 2,500, draft deed, valid IT, STC, royalty clearance, sketch map showing. After examination, it has been found that petitioner filed his application dated 2012-2005 had submitted only following treasury challan 2,500 rupees and draft deed. Therefore, it is evident that following documents are not produced by the ITC and STC royalty clearance sketch map.
You have submitted these documents.
Already submitted, my lord. Kindly see, my lord, the documents, my lord. Because, my lord, all the documents were issued in favor of the petitioner in the year 2003. If the document has not been submitted before the authority, the Xerox, how can I get from the record, my lord?
Yes, Mr. De, the documents have been submitted.
In spite of that, my lord, within that period, that within 6 months, Geo, that was not
If I not submitted within
my lord.
All the documents were submitted on the same date.
No, no. No, my lord, that is not submitted. That is the first 69, my lord. As per Geo, the following document will be required to be submitted. That is 6. Only 3 documents were submitted.
Please come to page 57. All these documents were submitted on the same date.
All these documents submitted previously. The copy of the documents has been submitted before the authority.
57, please.
Yes, my lord. 57.
57 এর পর দেখুন 58, 9 সব ডকুমেন্ট গুলো জমা দেয় যেগুলো দেয়নি করা।
My lord, reconsider the matter. my lord.
Yes.
Reconsider.
The
Geo
assistant
is
secretary
there.
has
Only
considered
one
first,
ground is there, my lord. That is not the ground. Only Geo within 6 months that was not given. For that reason, the party can be. So, my
Let it
lord.
be reconsidered.
Yes, ma'am. The order should be set aside, my lord.
Yes.
Earlier order should be set aside, my lord.
Yes. On prayer of the petitioner, the name of the third respondent expunged from the cause title of the petition. Stop the cause title be amended accordingly. Paragraph. The order passed by the Assistant Secretary, Department of Industries, Commerce and Enterprises, being the second respondent herein, on 20th May 2022 is assailed in the petition. Pursuant to an earlier order of this court, dated 14th March 2022 in WPA 1324 of 2022, directing the authority to consider and dispose of the representation submitted by the petitioner dated 3rd July 2021 upon taking into consideration Rule 61 of the West Bengal Minor Minerals Concession Rules, 2016 and Rule 34 of the West Bengal Sand within bracket mining, transport, storage and sale, bracket closed, rules, 2021 within a stipulated time frame. The concerned authority called for several documents from the petitioner, which were submitted by the petitioner before the authority on 13th May 2022. Stop. By the order impugned, the second respondent. The second respondent has turned down the representation submitted by the petitioner primarily on the ground that the petitioner submitted only 3 of the documents called for and failed to submit the remaining 3 documents. Stop. Paragraph, it appears from the receipt issued by the department upon submission of the documents by the petitioner on 13th May 2022 that all the documents called for by the authority was submitted by the petitioner on the same date. On the said date, on the said date. Stop. The concerned authority may have overlooked the said fact in dealing with the representation. Since the order impugned wrongly records that the documents required to be produced by the petitioner were not submitted within the stipulated period, the order required to be set aside and the matter sent for reconsideration by the authority in accordance with the paragraph. In view of the above, the order passed by the second respondent on 20th May 2022 is set aside. Paragraph, the repetition is disposed of, directing the second respondent to reconsider the representation submitted by the petitioner on 3rd July 2021. Upon affording reasonable opportunity of hearing to all concerned, including the petitioner, and in the light of the observation made by this court in the order dated 14th March 2022 in WPA 1324 of 2022, within 4 weeks, within 4 weeks?
Within 2 months, ma'am. Because there is some perhaps those documents were not
within 2 months from the date of communication of this order, in accordance with law. Paragraph, the decision taken by the authority shall be communicated to the petitioner within a week thereof. Next.
Appellate side daily list mention matters. Item number 489.
For the statement. But this is a second round of lead petition. But in earlier petition,
They are all served.
I'm for the state matter with along with Mr. Sinhara.
Private respondent has been served.
সেই জন্যই ওকে জিজ্ঞেস করছি না এখন এগুলো দিয়েছে ওইটাই করেছি ঠিক মতো জুরিসডিকশন করেছে তো আগের মতো না আবার বলবো আমার মধ্যে পড়ছে না তাহলে কিন্তু হবে ও যেটা দিয়ে তাহলে অর্ডার ক্যারি আউট করতে পারবো না
না সেটা জানি
Yes, what is the matter about?
My lord, in the earlier occasion, my lord had been pleased to pass an order which appears at page 40, wherein my lord had been pleased to give a direction upon the assistant engineer, the respondent number 5, to carry out certain directions. My lord, the order was communicated mistakenly, that misplaced from my custody. My lord, subsequently, when the order was not complied with, I made with my client made with the concerned respondents that it was told that the particular road does not fall within the jurisdiction of that assistant engineer, and he supplied the actual authority that appears at page 41, to whom I have made a fresh representation.
Representation.
The Assistant Engineer, Public Works Department, Huilik Subdivision Office at PD Sen Road, Chingsura, my lord.
Unauthorized construction.
Yes,
Subdivision always executed to Arambak Bela কি করে?
that information has been served.
এটা সদর হচ্ছে ওটা কি আরামবাগ হচ্ছে আলাদা সাবডিভিশন
PWD road
পিডব্লিউডি রোড
Yes,
should be the assistant engineer. The second,
second one.
My lord, earlier your lordship was pleased to direct the assistant engineer, but my lord, there is a communication from the assistant engineer that road belongs to the my lord, the jurisdiction of that assistant engineer.
that particular assistant.
That particular assistant. I don't know, my lord, which is the
Page
who is the
20
appropriate authority to
Page
consider.
28. The earlier representation.
No, no,
The
where is the
representation অর্ডারটা কোথায়?
communication from the assistant engineer.
অ্যাসিস্ট্যান্ট ইঞ্জিনিয়ার অর্ডারটা কমিউনিকেট করেছে সেই অর্ডারটা
That I at the outset said, my lord, that communication I have misplaced from my custody, that I have pleaded, my lord.
it has stated in the paragraph.
Paragraph, my lord, I have stated.
So now is the assistant engineer Hooghly?
এই জন্যই বলছি এটা
The
jurisdiction
Assistant
ভুল হলে
Engineer,
কিন্তু আমরা
Public
order
Works
carry out করতে
Department, Hooghly
Apply করতে
Subdivision
পারবো।
1, Office at PD Sen Road. He is the assistant engineer, I am told, my lord.
He is the relevant person.
Person that particular respondent has been represented, which appears at page 41, my lord.
Consideration.
ভুল হলে কিন্তু আমরা অর্ডার কমপ্লাই করতে পারবো না
Service.
এই জন্যই বলছি
None appears for the private respondents
please.
despite service. The paragraph, it is submitted on behalf of the petitioner. Claims the petitioner alleges unauthorized construction. None appears for the private respondents despite service. The petitioner alleges unauthorized construction raised by the private respondents upon PWD road adjoining his property, thereby obstructing his interest and rights. The petitioner submitted a representation before
Respondent number 5 is reacted to consider the representation.
this is the same person you are writing to. Assistant Engineer, Public Works Department, Hooghly Shodor, Subdivision 1.
Kindly let me check.
হ্যাঁ দর্শক ঠিকই বলছেন তোমার সেম পার্সন কিনা দেখো তাহলে কিন্তু
তাহলে that's-
কমপ্লাই করা যাবে না অর্ডার
The office at PD Sen Road,
অফিসের অ্যাড্রেস ঠিক আছে
Office is
Public
different.
Works Department, Hooghly
সেম
Subdivision.
পার্সন কিনা জানতে চাইছেন
Page
I'm told
20, page 41 are addressed to the same person.
My lord, may I take specific instruction and come back? Please, ma'am.
অফিসের অ্যাড্রেস ঠিক আছে কিন্তু সেম পার্সন কিনা এই জুরিসডিকশনের মধ্যে
My
পড়ছে
lord,
কিনা
keep
জেনে
it
রাখো।
active.
Problem will arise.
Yes, yes, ma'am. My lord,
Otherwise, my lord's order will not be my lord the complaint.
yes, yes.
Same problem will arise.
My lord, kindly adjourn the matter. Let me take specific instruction, my lord, and come back.
Petitioner complaints থেকে none appears for the এটা কোন কি বললাম বলুন তো এখানে?
এই অফিসগুলো তো আমার বাড়ির কাছে তো এই অফিসগুলো সব আমি জানি ঠিকানাগুলো ঠিক আছে কিন্তু ওই হরিপালের ওই অংশটা তার মধ্যে পড়ছে একটু জেনে নাও। ঠিক তা নাহলে অর্ডার ক্যারি আউট করে দেবে মানে পার্টিকুলার যে রেসপন্ডেন্ট তারপরে ডিরেকশনটা না হলে হবে
Sir, পরে বাকিটা কি?
তাই না
On prayer of the petitioner, the matter is adjourned. None appears for the private respondents despite service.
আসবে আমরাও জেনে নিই আমাদের মধ্যে পড়ছে কিনা
On prayer of the petitioner, the matter is adjourned. Paragraph, let the matter appear under the same heading on
Would it be possible before the vacation? Because
come back 21st December because
As you know,
if the representation is not
Madam,
for the proper person.
much of 21st December.
ভুল ভাল ভালো হবে না জানো কথাটাকে ক্যারি করে
Appellate side daily list, mention matters, item number 490.
Lordships, in item number 490, my lord, I beg to appear for the petitioner, your lordships. The matter relates to removal of unauthorized encroachment from PWD land.
I am submitting every officer.
Mr. Dev?
Lordships, petitioner made this. Yes, your lordships.
All of them?
Yes, there are 4 private respondents.
Where is the track report? Where is the service?
That is long back, my lord, on 14th September
I have received.
Where is the track report?
Track report is not included.
Then no service.
Lordships, Lordships, it was served. Not only that, before this matter was mentioned for upgradation, before my lord, the notice for upgradation was also served. Anyway, my lord, let me come back with press service again. Here.
Private respondents have not been served. There is no document of service. Only the
Lordship,
proceedings are there.
let me come back with fresh service, your lordship.
Since service upon the private respondents is not complete, comma, let the matter stand over till 8 January.
Lordship.
Appellate side daily list mention matters item number 491.
I am for private respondent 8 and 9. Petitioner Lordship.
Lordship, I am for the state.
Matter relating to Lordship, unauthorized construction Lordship. I have made representation that is been still pending Lordship. My Lord, I have a Lordship, sir. I have a preliminary. My Lord, respondent number 8 and 9, the private respondent. My Lord, I have a preliminary objection, my Lord. In the whole pleadings, in the petition and in the respondent, he has stated that there is an illegal construction, but he has not stated on which plot of land. It is impossible for my land, Lordship. In front, beside, all these pleadings are there, specifically nothing is there. That should be considered according to case 19.
For the state?
Lordship, I am appearing for the state, Lordship. Representation received, Lordship, but no documents is annexed, Lordship.
What document do you require with the representation?
No documents annexed. Which land is which land is occupied, Lordship? Nothing is annexed. Only representation was sent. Representation, Lordship, may be considered upon servicing the documents, Lordship, relating to the land in question. Relating to the land in question.
If required, I submit a document.
It is stated that the petitioner is occupying a particular land. That is stated, the LR plot number, everything, all the details are stated. The petitioner's land.
Yes, Lordship.
And adjacent to the petitioner's land, there is government land, which is occupied, which is allegedly encroached. So what other detail do you require? Petitioner is not supposed to know the details of the allegedly encroached land. It is for you to demarcate, madam.
Lordship, communication has been given to the assistant engineer, Holde Highway Subdivision, Lordship, for taking steps, Lordship.
Let the representation be considered. You'll be given an opportunity of hearing. Where is your representation?
Case 19, Lordship.
Is it PWD land or government land?
That has also not been government land, Lordship.
Stated government land.
Government land.
So the 62 Act will come into
62
play.
Act.
Affidavit of service. The petitioner claims to be the recorded owner of the plot in question and complains that the private respondents have raised unauthorized construction by encroaching upon government land, encroaching upon a portion of government land, adjoining his plot, comma, thereby obstructing his egress and ingress. Stop. The petitioner submitted a representation before the concerned authority on 23rd August 2023, which is yet to be considered. Stop. The petitioner prays for a direction of the authority to consider the representation at the earliest. Paragraph is submitted on behalf of the state respondents that the subdivisional officer, the third respondent, be directed to consider the representation in accordance with law. Number 2. Yes, government land, madam.
Government land.
62 Act, the SDO is the authority. You are representing the state, madam. Paragraph in view of the above, the petition is disposed of, directing the third respondent to consider and dispose of the representation submitted by the petitioner dated such and such within 3 months from the date of
Respondent number 3.
3, yes. 62 Act, the third respondent is responsible. And for the 64 Act, the fourth. Within 3 months from the date of communication of this order, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioner and the private respondents, comma, in accordance with law.
Yes,
Next.
Item number 492.
Next is also I appeal for petition.
Yes. You're the petitioner?
Same,
State?
My lord, I beg to appear for the respondent number 8 to 12, my lord.
Lordship, petitioner herein is the secretary of the
Yes?
petitioner herein is the secretary of the Samavai Samiti, Lordship. There is a Samavai Samiti. In front of that,
State?
I served notice, Lordship. Notice has been served.
Mr. Bandyopadhyay, may I request you? Please serve a copy to Mr.
Yes,
Bandyopadhyay.
Lordship. Page
State
38,
is served. Yes, what is the matter?
unauthorized construction in front of Samavai Samiti, Lordship.
Front of?
Samavai Samiti. There is a Samavai Samiti.
You are the secretary of the
I am the secretary, Lordship. I made representation, page 38. That has to be considered, Lordship.
Before going into that, my lord, this is the second round of litigation. My lord, firstly, the matter was filed, that was withdrawn, my lord.
Lordship.
Stating that, my lord, they have stated that, my lord, kindly takes up page 44 of the writ petition. But the first paragraph, learned counsel for the petitioner submits that certain averments and documents have been left out, and such the petitioner seeks to withdraw and such. Well, they withdrew. Well, on the same self footing, this matter has been filed.
Liberty to file afresh.
Well, nothing new has been filed in.
Nothing is required. Liberty was granted to file afresh. on
Certain
the-
averments has not been.
My lord, that is my lord, first, my lord. And second of all, my lord, the objection against whom they have said, my lord, we have obtained already permission, rather lease, my lord. My lord, my lord, this has been. Huh? Irrigation.
When was this granted?
My lord, 22, my lord, 2022.
This is LR plot number 940. And the petitioner is on 931 and 933.
Yes, ma'am.
So how can 940 be adjoining 931 and 933? Let the authority decide the representation. You'll have your opportunity of hearing before the authority.
Page 38.
This is a license.
Yes, ma'am.
A temporary license.
Yeah, temporary license.
Affidavit of service. The none appears for the state respondents. Mr. Bandyopadhyay, regularized full. Please serve a copy to Mr.
Lordship. In court, sir. আজকে দিয়ে দেবো।
The petitioner claims to be the secretary of Krushi Unnoyon Samiti Limited. Which is the recorded owner of the plot in question. The petitioner complains that the private respondents have raised unauthorized construction by encroaching upon a portion of government land adjoining the plot owned by the Shomiti, thereby obstructing its egress and ingress. The petitioner submitted a representation before the concerned authority on 28th August 2023, which is yet to be considered. Stop. The petitioner prays for a direction upon the authority to consider the representation at the earliest. Learned counsel for the private respondents submits that the private respondents have been granted temporary license in respect of the portion of the plot wherein they have raised construction. Paragraph Learned Counsel for the state respondents submits that there are two subdivisional officers. Who is the authority?
Respondent number 3, Lordship.
One is Kontai subdivision, Jagannathpur. The other is Kontai subdivision, Kontai irrigation subdivision,
Respondent number 3, Lordship. Kontai subdivision.
Jagannathpur.
Jagannathpur.
The third respondent be directed to consider the representation in accordance with law. Paragraph in view of the above, the petition is
ইরিগেশনের
directed
কিন্তু
to the
জায়গা
respondent
ওটা দেখে বলো
to consider and dispose of the representation submitted by the petitioner dated such and such within 3 months from the date of communication of this order, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioner and the private respondents, in accordance with law.
Yes.
Yes, for the discussion.
Item number 501.
In this matter, we have the petitioner, but there is an application of contempt. The matter was heard, my lord, the compliance report was filed in for my affidavit. So, my lord was directed to use me, my lord, an exception to the affidavit. My client, my lord, has gone to abroad, for working purpose. So, my lord, I please that the matter. Yes.
You come after vacation?
After vacation, my lord, because it will take some time. When he will come back from the.
No,
He has gone to abroad.
may I tell Lordship only one thing? Let him take time, but the thing is this is not a writ petition. It's a matter arising out of contempt proceeding that the my lord's order has not been complied with. Now, I have filed a compliance report. Now, it appears from the said report that my lord's order has been complied with. The order was direction to take a decision in the matter of a pending application. That decision has been taken. Now, he may say that the decision is not, my lord, according to law. He may. That's
No, in terms of the order of the court. What is
now,
the direction of the court?
now for that, I mean, now for that, I do not think that the client's presence is or the petitioner's personal presence is
Find an exception. I think.
Exception, because the order has not been complied in terms of the order of the court. That is the.
I'll fix it. At best, I can fix it in January. If you are ready with the exception, fine. Otherwise, I'll dispose it of.
Yes.
At least 3 months time.
Well, 3 months contempt petition pending
Well,
in the High Court.
As a last chance, or 3 months.
No, 3 months এটা হয় না কোনোদিন। Contempt application because your client is not here.
So, my lord, kindly adjourn for 3 months, my lord. These are last chance. Kindly record my condition. I shall not pay for time. I shall not pay for time.
Filing contempt petition and he has gone
Kindly adjourn the
abroad.
matter for 3 months, my lord.
January, if take verbal instructions if you want.
Yes.
But instead of March, my lord. Kindly.
They are, my lord, they are may not be, my lord, they are,
31st January.
my lord, kindly record an order that the
Then a
ঠিক আছে, তাহলে আমি dispose করে দেব, কথা দিলাম।
further extension of time
Yes.
to submit the exception as sought. Paragraph let the matter appear under the same heading on 31st January
31st January, my lord. 31st January.
31st January 2024.
My lord.
No further extension.
No, I shall like to not pay because this is my
Next.
submission.
Item number 503. Group 7 motion.
This is my appeal. Now, on the last occasion, that is in the month of September, 20th September 2023, Mr. Debray's client filed one exception. That exception was not correct. Report. Accordingly, your lordship was pleased. Your lordship, can you see the report of the secretary dated 20th September 2023. They are to file a report in the form of affidavit.
Yes.
আমি তো জানতাম এমনি
This client actually agreed to exempt the taxes.
yes that is why my lord, balance is disputed, my lord, balance amount also, my lord, they are consequently said. A short affidavit, let him file in the next week, your can be disposed of. Otherwise, nothing will be on the record. That is the whole trouble.
Be taken on record. In the meantime, why don't you check the
Yes. আরে এই তো দেখো না ভাই, আমি তো কাল রাত্রে দেখে বার করলাম, আমি তো ভুলে গেছিলাম। আমি তো ভুলে গেছিলাম, আমি তো বলছি তো। Report in the form of affidavit submitted on behalf of the state respondent is taken on record for further report. Very well. You file it. After calculation is, yes, this my lord, after that calculation, this is the next part, which is Mr. Chatterjee also submitted this part. For state of West Bengal banded region. No, not from up to July. It's not correct. July up to July. No. In the state government notification, your lordship, can you see what is the state government notification? Your lordship, can you see paragraph 9 of the writ petition? Thereafter relaxation.
Why don't you use an exception to this?
No. I'm just showing your lordship the notification passed by the state government. Your lordship, can you come paragraph 9 of the writ petition at page 9. Hey, P7 টা বার করে কোথায় আছে? After the election is over, state government issued a notification of 5th May.
that up to 13th of July.
No, no, no.
Total ban.
Yes,
Then
yes.
after, my lord, time to time 50% allowed. How can I know that this vehicle is flying?
I am showing to your lordship. Why Mr. Devra is so hurry?
I am not hurry. I am not.
Paragraph 9, I have stated that the notification was issued for restriction.
Yes.
That is, and these are the notifications. Your lordship can come page 65. Page 65. 14 July notification. From May to July, the earlier notification immediately after the election, it was not with me. But thereafter, I have collected all these notifications.
That
From-
is expensive.
No, that they have said that
This is till 15th July.
this is 14 July, page 65
Till 15th,
till 30th July. Your lordship can see the third paragraph.
okay, so that is July 2021.
July 20, I'm coming. Now your lordship can come to next page. 29 July. The restriction which was imposed on 14 July, 15th August. Then your lordship can come to next page, 67. Extended up to 31st August. And the relaxation has been given where interstate vehicles were not there. Then your lordship can go 68. 15th September. It was continued up to 31st of October. Now they have indicated up to 31st of July without looking into their own notification. Well, this is something unfortunate. They have taken 3 months and they have done these things. This is unfortunate, my lord. This person should be penalized.
Let us see what Mr. Devra responds.
The partial relaxation is there, madam.
And yes, you kindly see what is the personal relaxation.
Relaxation was there.
No, what is the personal relaxation? Your lordship kindly see.
14 July relaxation was there.
With the following additional relaxation, 28 July, coaching centers, etc. Nothing more, nothing else.
Public transport.
Only
one minute, second. Movement of public transport, including interstate.
intrastate. In bracket, oh, it is intra-district.
Local taxis.
Page 65.
Rickshaws will be allowed with not more than 50%.
That is inter-district.
States, not interstate. Within the state.
Within the state.
And this is an interstate vehicle.
But I have seen it. If it is not there, I am not the person who can place a notification which is not said something else.
I have gone through the entire notification, brother.
Yes.
Entire notification, time to time that has been restriction has been
and the notification
has been made.
Restriction with regard to the interstate vehicles.
No relaxation.
Relaxation. Otherwise, till 31st October, the petitioner is entitled.
28 August.
Is up to 28th August I have collected. It was up to 31st of October.
You have the further notifications?
No, Manoj, it has not been uploaded in the website.
Not been uploaded?
Not been uploaded. I have searched everywhere in banglarmukh.com, bengalgovernment.com, everywhere.
31st October.
No. Local train, train service and interstate vehicles are stopped up to 31st of October. Let them say it is not correct.
Record this statement.
Yes. I have stated. I have
record this order. That will be better.
No. I have stated on oath.
Is why Lordship kindly record this.
It is already in the record.
Lordship pass an order. That is better.
It is already
recorded.
Already recorded in the order.
Pass an order, my lord. Today I have submitted this. Yeah, that has not been complied with?
This is not submission of, this is not compliance at all. This is only till 13th July.
July.
5th May to 13th July. That is the first notification after the election is over.
After that,
Thereafter, my lord, some time to time 50% capacity when I have to, my lord.
where is that 50% capacity? It's not there on record.
Interstate
Interstate.
Interstate.
Thus, the relaxation is intrastate, which is inter-district.
Lordship, kindly clarify the position, pass and order. That will help you, my lord. Otherwise, my lord, department says, well, what is the order? Where is
No,
the
no,
order?
no, department cannot read it. IS officer. IS officer cannot read it, English. English.
You know, I don't know everything, but they are not.
This is something unfortunate.
They are nothing doing, that everybody know.
And your lordship, hear the matter on 20th September. Thereafter, your lordship held the circuit bench. Your lordship was not before the vacation. And now, in the month of this, after 3 months,
2 months holidays already gone.
1 month,
2 months. State government holidays much better than ours.
20 days only.
For Puja also they are holidays.
Your lordship, kindly ask them within 7 days, let them file proper things.
The proper assessment.
Proper assessment.
Proper assessment in 7 days. Not beyond that.
Calculating the exempted period of interstate.
Yes. Today.
তুমি এটা দেখো নি বোধ হয় না?
The learned
Most likely you have not seen it.
has submitted a calculation regards to
কিন্তু দিস না 31st of the আমার চিফ মিনিস্টারের
payment of
নোটিফিকেশন।
tax.
আরে ভাই বাংলা বাংলার মুখে নোটিফিকেশন একটাও আপলোড করে।
Exemption period
হ্যাঁ একটাও আপলোড করে।
due to the COVID-19 pandemic. From 5th May 2021 to 13th July 2021. Stop. 5th May 2021 to 13th July 2021. Stop. Paragraph
আজকে দিয়েছে 5/12/2023 মানে কালকে
It is submitted by learned counsel for the petitioner that the restriction on movement of interstate vehicles, interstate vehicles commenced V-Day notification. The first notification is 14th July.
No, it was immediately after the 5th May. From 14th July,
From 5th May 2021
5th May,
and continued till 31st October 2021 by virtue of several subsequent notifications issued by the government. Stop. Paragraph in view of the above, the respondents are directed to take note of such restrictions till 31st October 2021 and reassess the
ডিটেল নোটস ফাইল করেছিলাম ওদের ওখানে
tax and penalty.
ট্যাক্স এন্ড পেনাল্টি।
The tax and penalty payable by the petitioner. What is the period to be reassessed?
মানে পিরিয়ড টু অ্যাসেস ফ্রম এপ্রিল 2021 to 31st October 2021, 1st April 2021.
What is the exemption period?
Yes,
You have to pay for which period?
thereafter. And prior to that,
Prior to
I have paid the tax. Your lordship kindly go on. Yes, correct. Your lordship kindly see. Prior to that, I have paid 1 minute.
in April, you have paid? April 2021?
No. At that period, the office was closed. Nobody was there to accept the tax. Because I have paid the additional tax. এই কোথায় গেল রসিদটা গেল কোথায়?
Well, let me say prior to and thereafter.
হ্যাঁ
কি বললাম last time?
Your lordship kindly come to page 43, yes, 43, correct, 43. I have paid up to May, 6 May 2020.
Payable by the
6 May
petitioner
2020.
Yeah, that's right, from 7th February, and at that time, COVID was continued. What can I do?
prior to and after the restrictions, prior to imposition of the restriction,
Manoj, there are two sets of restrictions. In the first wave, up to 30th September. Then in the second wave, from 1st April. Two sets of restrictions are there that I have stated in the writ petition.
consider all the
Yes.
periods. Yes.
Because your lordship can indicate, if your lordship wants to indicate, if it comes to your lordship, that the restrictions were imposed from March 2020 to 30th September 2020. First wave. Then October, November, December, the relaxation was done.
যেখানে রেস্ট্রিকশন বললাম না এই থেকে বললাম তো ওখানে in the first phase করুন in the first phase from
No. April 1st April 2020 to 30th September 2020. That is the notification. 10th August notification.
and in the second phase from 5th May 2021 যেটা বলেছি দেখো
State of West Bengal from 5th May. Odisha was from 1st April. Because Odisha did not allow anybody to cross border.
reassess the last line কি বলো reassess the by the petitioner that to imposition of restriction as well as after relaxation of the restrictions by the government of West Bengal as well as Odisha. When can you come back with the assessment, Mr. Devra? This period has to be exempted. And in principle, you have agreed to exempt.
Yes, yes. Why at the time of restriction, how it is possible to take up?
But
So
the
lordship
period
will keep
of
some time because I have to talk with the, my officer talk with the Odisha authority also. They take notification
yes.
also. Otherwise,
But please instruct your officers to take into account the entire period of restriction.
Up to this, your lordship can indicate up to this. Because from November 2021 till date, I cannot deposit the tax. Because earlier period is in dispute. That's the whole difficulty. And nobody knows whether they will charge penalty or not.
Fresh calculation. Let us see.
Nobody knows.
Let the matter appear. And when can you come back, Mr. Devra?
2 weeks time. Give 2 weeks time.
This takes us to the vacation.
We'll go to the vacation.
Please come in the first week of January, 5th January.
Lots.
Mr. Chatterjee.
Lots.
Oh, well, that 5th January is not here.
You can see in the month of May.
May.
This year's May is January next. Is that right?
Oh, 2 weeks, my lord, into vacation. Today we are on 6th.
Just on the case.
On 20th. Let it be on 20th. Let us see what is the progress. Let us see what is the progress.
20th December, 2 weeks.
প্রোগ্রেসটা দেখে নি না ভাই অ্যাটলিস্ট মক্কেলকে কিছু বলতে তো পারবো বলতে পারছি না একটা কথা
নাও ছুটির আগে একটা নাও
একটা কথাও বলতে পারছি না। বিপ্লব নামগুলো সব দিয়েছো
I am for the respondent, my lord. State also party, my lord.
State who is appearing?
Answer Mondal.
Please do not give his name.
My lord, the petitioner is a
Rajiv.
The petitioner is a registered leaseholder with the Indian Railways, my lord. My lord, in pursuance of carrying out the operation of the lease, my lord, petitioner loaded one consignment at Ahmedabad, my lord, where under the circular he has to declare what is the material which wants to get transported, and in due course, my lord, after getting the money, lordship obtained the money receipts and also deposited the manifest, clearly stating the overall weight of the consignment, and that has been countersigned, re-verified,
Then it was allowed to be get dispatched to Shalimar, my lord. Now at Shalimar, my lord, when the materials came, they were declared to be overloaded beyond the carrying capacity. Carrying capacity is 23 tons. It was overloaded by another 4 tons to 5 tons, my lord. I made a representation before the competent authority for repayment. Now that was not acceded to. I deposited the punitive demand. On protest, I approached before this Honorable High Court with a prayer for seeking repayment and correction of the in-motion way bridge, my lord. Because the Western Railway has verified it and said that it is within that carrying capacity for which it was allowed to transshift. Now here the another railway under Indian Railway is disputing the same. So both the railways are making two different statements over a single consignment. Now after Lordship's order, excellent. After Lordship order was passed, my lord, thereafter it was carried on. Payment was carried on by in presence of the legal metrology, but not in presence of me, Lordship, though I was directed to be there, but I was asked to leave because the payment could not.
Please wait, let them finish their important talk, then we'll start again. Have you completed, sir? Can we start?
Report submitted, my.
Yes, continue, please.
Now, my lord, thereafter, my lord, it was the direction of the Honorable High Court that it has to be in presence of the railway officials, legal metrology, and myself, my lord. Legal metrology and railways were present, but I was asked to leave because it was not carried out within the official time, my lord. It was the direction of this Honorable Court. Now, I am not joining issue on that, my lord. The thing is this, my lord, I was provided with the payment report. From the payment report, it has appeared that the payment was undertaken on 60 times. The wagon was taken to and fro, and on the report which indicates that the in-motion beverage has shown different readings. Sometimes it is of 31 tons, sometimes 32 tons, sometimes 38 tons. This is how I have.
There is anomaly.
So there is anomaly, my lord. Now the question is, my lord, here in the present writ application, I have asked for the refund because there is a division bench order to that effect. Single bench order is also there. And I also say that the exercise of repayment which was carried on before I approached before this Honorable Court on these two occasions, that is not in accordance with the law, because the circular clearly says that when I am depositing the money receipt and I am submitting the manifest indicating the total weight of the consignment, it is the duty of the originating station. Lordship has seen those circulars, I have annexed here, to wait until and unless the payment is done to the satisfaction of the railway officials, the consignments cannot be carried on. And if it is detected that there is an overloading, then and there the materials will be offloaded. Because the Railway Board circulars is very strict on this, that no overloaded consignment will be allowed to take in because it affects the security of the passengers. Now, that was done there. Now the Railway Board, Railways report is silent on that aspect, whether they have carried the payment or not, because there is a manifest here which has been countersigned by the railways, my lord. Yes, that is at page 54. Now, see, this is the manifest, page 52, 54, annexure P2. Lordship will see that it has been, I have indicated the weight, 22,800 kilos. Now, that has been chief luggage, Ahmedabad Western Railway. Now, my lord, prior to that page, my lord, page 53 is the money receipt. And the money receipt can only be given as per the circular says, my lord. May I?
Not clear, my lord. Page 53.
May not be clear, my lord, but I will only indicate, but it has not been disputed either by the legal metrology or by the railways. Because under the agreement, my lord, for availing each days of parcel space, I have to deposit advance freight charges. Because if I do not, my lord, they will not give me the carriage or I will not be allowed to load. So this is a precondition. So when the material has been loaded and it has been countersigned and it has reached to Shalimar, it is assumed that I have paid the advance freight charges and they have issued the money receipt. And when money receipt is issued, it is also assumed that it has been properly weighed at the originating station, because the commercial manual is very specific on this. If you Lordship kindly come to commercial manual 1451. My lord will.
Shalimar, it is 27.2.
Lordship kindly see 1451B, top right. This is the manual. One. When the 1451B, top right, it says, my lord, it's no uncertain term that it will only be issued upon proper payment in front of the railway officials at the originating station. So, my lord, on all occasions, these two railways cannot come up with two different pleas. One says that it is within the permissible limit, another says that it is beyond the permissible limit. Now, my lord, lordship has directed them to carry out the payment. It is showing anomalies. And this particular weighbridge is a subject matter of several litigations in past. And this honorable court, in direction by the coordinate bench, and also which has been affirmed by the honorable division bench, has specifically came down heavily upon the officials for not maintaining or for the functioning of the weighbridges. The rules and regulation which governs the functioning of the weighbridges I have annexed here in the writ application. And also the legal metrology, I am grateful to my learned friend, the legal metrology, who has at least pointed out the correct proposition of law by saying that how the payment has to be done. The payment has to be done by maintaining a minimum speed of 1 to 15 km per hour. Your lordship will see this from the legal metrology's report. Your lordship, kindly come to page 2 of the legal metrology's report. Page 2, paragraph 4. Lordship has found, I say that the maximum permissible error of the automatic railway weighbridge will be such as specified in the 7th schedule heading C, part 2, and any reading within the MPA can be treated as correct reading. The minimum operating speed and maximum operating speed of the automatic railway weighbridge are 1 km and 15 km per hour respectively, as per the model approval certificate. If the train does not pass on the automatic railway weighbridge within the range of the operating speeds, the obtained readings may subject to error. So the railway lordship will find from the report, nowhere has stated that it was done within the speed as reflecting in the legal metrology's report. And also, my lord, will find from the legal metrology's report that they have issued a certificate which they have annexed at their page 9 of the legal metrology's report, which says that it has been certified that the weight is proper and okay, and the functioning of the weighbridge is proper and okay, but it has been issued in interval of 1 year, whereas the commercial manual says the certificate of weighbridge has to be issued half yearly. And only upon the direction of this Honorable High Court, my lord, the weighbridge was again rectified. And it is there in the legal metrology's report. Now, my lord, before my learned friends make his submission, I know what will be his submission. His submission will be railways power to repayment under section 78 of the Indian Railway Act. Now, section 78, my lord, I am handing over. Lordship, you will find this is section 78 of the Indian Railways Act. Yes.
Section 78.
78. It gives the power to the railways to re-verify, remeasure, recalculate. It gives the power to the railways for second payment. I am not joining issue on that because my plea is this: they have the power to do so. But when one payment has been done at the originating station, then in case there is a surprise check where it has been done here, then that has to follow the FM circular 7 of 2021, which says that in case of surprise check, then I have to be notified first. Lordship has gone through this in details in previous orders, my lord. And then, my lord, I will only hide.
Please show me the circular in this. You've annexed it to the petition.
Yes. Circular I have annexed in the report.
In the exception.
In the exception. My lord, kindly come to page 17 of my exception.
Yes.
Page 17, my lord, this will appear at page 20, 3.2. In case, Lordship has found, my lord.
3.2,
Page 23.2, in case of dispute regarding overloading detected as a result of surprise check in respect of consignments of branded items which are of standard sizes and uniform weight with weight stenciled on the packet such as dairy products and FMCG, the number of packages in the parcel vans detected to be overloaded may be counted and the average weight of a packet may be determined by weighing few packets on random basis in each different segments of consignments loaded at the destination point. In presence of the representatives of the consigners and consignee and 2 gazetted railway officers, one from the commercial and operating department and the second from any other department, punitive charges already raised may be revised based on the payload determined in this manner with the approval of senior DCM of the division of the destinations point. My lord, it gives us right to be represented over there. Now, my lord, Honorable Division Bench, the point was raised whether this infringes Section 78 or not. Then that has been answered, Lordship, may I, Lordship, I have annexed in the Division Bench order, page 99, on this.
Yes.
Would you kindly come to page 99? I'm coming. Yes, this is the Division Bench judgment, my lord, where this point was taken. It will appear at, আমি বলছি, yes, page 106, my lord. Heavily relying on the facts as recorded by the orders of the Honorable Single Bench, Learned Counsel for the writ petitioner submits that the dispute does not lie who are the powers of the railways to measure, weigh, or reweigh the in exercise of power under Section 78 and 79 of the Railways Act. But the dispute lies with the specific grievance raised by the writ petitioner that the in-motion weigh bridge at Padmapukur was defective, and as such, the defects in weighment stares in the face of the record, since at the point of departure of the said consignments, the weighment was found to be within the permissible limits. It is reiterated by the Learned Counsel for the writ petition that the goods in the consignments were of nature which would were not of a nature which would gain in weight during transit. To the contrary, the Honorable Single Bench had noticed that the goods comprised of hard parcels of electronic items. It is submitted that there is no effective denial by the railways of their failure to execute in letter and spirit the direction of the Honorable Single Bench dated 26 August 2021. It is submitted that the conduct of the railways in not producing the empty general coach for payment and suo motu taking steps to repair the in-motion weigh bridge at Padmapukur betrays an activity which is subservient of the directions of the Honorable Court. Here also, my lord, they have, before the weighment actually took place, they in themselves ascertained whether it is correctly functioning or not by giving 60 rounds of trips here and there. But still, after that, my lord, it showed anomaly. Now, in above view of the matter, the Learned Counsel of the writ petitioner submits the Honorable Single Bench was justified in directing return of the punitive and warfare charges, as well as in imposing cost on the concerned railway officials. Appearing for the Controller on Legal Metrology, Mr. Sen Learned Counsel submits that the Controller of Legal Metrology has always acted in terms of the solemn orders of the Honorable High Court dated 26 August 2021 and 11 January 2022. The Controller of Legal Metrology has stated that the last correction of the in-motion weigh bridge at Padmapukur, here also Padmapukur, my lord, was carried out on 14th September 2021. In absence of proactive steps taken by the railway authorities to act in terms of the orders of the Honorable Court, the Controller of Legal Metrology cannot be held to be responsible for any violation. Having heard the parties and anxiously considering the materials placed, this court finds that the orders of the Honorable Court dated 26 August 2021, 11 February 2022, 31st March 2022, 7th April 2022, and lastly on 8th April 2022 disclose detailed application of mine to the principal facts in issue, namely the correctness of the in-motion weigh bridge at Padmapukur to be checked on as is varies basis by the Controller Legal Metrology and weighment of empty general coach carrying the consignments. This court notices that a direction passed by the Honorable Court on the above two issues do not in any manner affect, impact, or infringe the power of the railway to weigh or reweigh consignments as provided in section 78 and 79 of the Act. Whatever prayer I have made, Worship, I am not at all challenging section 78, 79. Here also the same thing happened. They made a submission that we have a power under section 78 and we can do whatever we feel like. But my prayer is only subjected to two things only.
Your own correctness of the way.
Yes, correctness of the payment, because one railway is saying that it is within the tolerable limit. Second railway is saying that no, it is above the tolerable limit. This court finds that the German issue before the Honorable Court was not the power to carry out the payment in terms of the statute, but specifically the correctness of the payment carried out in the facts of each case connected to issue A and B as recorded above. Having considered the order impugned dated 8 April 2022, this court is of the view that the issues flagged by the Honorable Single Bench are embedded in the hard facts, and it is the dereliction of their lawful obligations by the concerned respondents as imposed by the solemn orders of the Honorable Court arising out of such facts that has resulted in consequential orders of imposition of cost and refund of punitive charges. For the above reason, this court is unable to discover any infirmity in the order impugned of Honorable Single Bench dated 8 April 2022. The order impugned dated 8 April 2022 stands accordingly sustained, with the solitary modification that the order on payment of costs shall not apply against respondent number 6 in each of the appeals, since no cause of action has been espoused by the petitioner in such railway officials operating in railway jurisdiction outside ACR. But this was the observation, my lord. Now, my lord, I am not challenging the railways authority of remeasuring of section 78. They can do so. But my prayer...
In fact, your prayer is for remeasurement.
Yes.
For repayment.
Repayment under section 79. And I have annexed, my lord, all the provisions pertaining to the use and care of the way bridges as per there in the commercial manual. Lordship will kindly come to page 53 for once of my exception. Lordship, see page 53, clause 1431. Testing of way bridges by the bridge inspector. Lordship has found page 53.
Yes.
So clause 1431, all way bridges will be tested half yearly. Lordship, kindly mark this, half yearly, by an inspector of mechanical department. After testing, he should furnish a certificate. Lordship, kindly see who will furnish a certificate. Mechanical department. For each way bridge showing that it has been adjusted and tested. This certificate must be displayed in the way bridge house until the next inspection and issue of fresh certificate. The date of each testing should also be painted on the way bridge. So along with the legal metrology, it is also the duty of the railways, at least by their department from the mechanical, my lord, to see half yearly, but 6 months basis whether the way bridge is functioning or not. No such certificate has been annexed by the railways in the report, my lord. So my prayer is before your lordship is this: the punitive amount which is lying with the railways, my lord, that should be refunded as per the honorable division benches and single benches order, and also as per the report which says that the weighing machine is not functioning properly, and also, my lord, the payments are showing erratic. For that reason, I should not be penalized.
Report of the metrology.
Metrology reports, my lord, is there.
The second payment.
Second payment report. Second payment report I have also annexed, my lord.
To the repetition.
Yes, page 116.
To the repetition.
Yes. Page 116 it starts.
This was after the...
Yes, after your lordship's order, this was how it was carried out. They have annexed 4 to 5 reports and each shows different reading. Sometimes lordship will see the weight of the parcel space should be 32 tons. It is page 116, my lord.
Yes.
It is showing 31.60 at page 116 at the left hand column, my lord. We'll find 31.60. Then in the next page, 31.80. Then on the next page, 31.20. The next page, 32. The next page also 32.
But there should be a permissible limit within which it can
Yes,
vary.
permissible limit, Lordship, is
Within which it
above
can
4 to
vary.
5 tons. Legal metrology's case is this. The permissible error is what railway says is not 1 ton. Railway says it has to be within 1 ton. But legal metrology says it is 20% of the women. That means if it is, Lordship, suppose I load 2 tons. Railway will say that if you load above 2.5 ton, that is overloading. But as far as legal metrology is concerned, it has, if it is within 5 ton, then it is okay for them.
So this should be the prerogative of the railways.
Railway says it is within 0.5 ton.
And these the variations in the weight as in the reweighment, there should be some limit within which some relaxable limit.
Relaxability, that is the, my lord, 1 ton relaxability has been given for the by the railways. That I will show, my lord. I have annexed that.
This is not with regard to loading. This is with regard to the correctness of the
Yes, yes.
weighbridge.
That is there, my lord. I am coming at page 7.
The differences are not much. 31.60, 31.20, 31.80.
Yes, Lordship, kindly come
32,
to
this is whether this is within permissible limit.
Lordship, kindly come to page 17.
Reweight.
Page 17.
Page
Page 17 of
of
my report. Exception. My page 17 of my exception.
yes.
Clause 1.3.
Tolerance limit is
Tolerance with a view to account for possible variation in the way bridges. It's at a tolerance up to 5% over the permissible carrying capacity for each compartment shall be permitted in SLRs. The tolerance limit of 1 ton over the permissible carrying capacity shall be permitted in case of parcel vans. 1,000 kilos can differ here and there.
this is with regard to your loading, but there are little differences in between the way we.
But it cannot be ascertained, my lord, what was, whether the machine was functioning properly or not when the second weighment was done, because it was not done in presence of the legal metrology, not done in presence of me, although the rule says it has to be done. And whether that exercise is legal or not, my lordship will definitely adjudicate that aspect. Because once a railway has stated that it is within the permissible limit, then again they are doing it without giving me any prior notice and through a surprise check, whether that is permissible, but that has been gone into by the division bench. But that is no way affecting the right of the railways under section 78.
So section 78, 79 is not under challenge in the report.
No, it's not under challenge. I am not at all disputing, my lord, because what I am saying is this.
You are asking for implementation of 79.
Yes, implementation of 79 and also
that exercise has been done, isn't it?
17, and also kindly come to page 27, my lord. This is very important.
Of the exception.
Yes, of the exception. It's a master circular payment of 2019, clause 1.1.13.
Yes.
It says, my lord, punitive charges for overloading, lordship has found, punitive charges for overloading, if any, should be realized at the originating point itself, and it should be mentioned in the RR. That rate has been weighed and all the charges, including punitive charges, collected. There should be indication in FOIS against this, the train, that is, it has been weighed. Reweighment of such wagons rakes at en route destination should normally not be done. If I have overloaded, it should be reflected in the money receipts that this much has been overloaded at the original station. We have accepted the punitive charges. Then it will be sent. But here, lordship will find from the money receipt, no such indication has been given. I have annexed the money receipt. Railways are here, my lord. Legal metrologies are here. They will definitely say whether this provision is applicable or not in my case. Well, had I overloaded, then that indication ought to have been there in the money receipt. Money receipt is silent with regard to that. No punitive charges were collected at the originating station. Now they suddenly say that I have overloaded. They are disputing their own statements. And I have been penalized because of the fight between the two zonal railways. This is my respectful submission at present, my lord. Because, and also, she will kindly come.
Primarily, it was done in your absence. That is the primary issue to be considered.
It might done in my absence, and although that should not have been done. My point is this, my lord, once it has been weighed at the originating station, because whether it has been weighed or not, that my learned friend will say. Because if it is not weighed, there has to be a reason for that. That reason is as per the policy of 7 of 2021, that if the originating station do not have the facility of payment, then that should be recorded and there has to be a proper reasoning. Clause 1.2 says,
No, that's not applicable at all. It has been weighed under
yes, clause 1.1 says that originating station should weigh the parcel space before the same gets dispatched.
That has been done.
Yes, and 1.2 says that if it is not done, then proper reasoning has to be there.
No, it has been done, certificate issued in that.
This is my contention.
No, the documents are there. Let us hear the railways.
Learned friend, my lord, taking my lord good story, but not the all section which is covered by the Railway Act. Your Lordship, at first, kindly see that section 64, my lord. Railway Act, my lord. Learned friend said received and other things. That is the primary evidence of this case, my lord. But Act it said, my lord, quite defined, my lord.
64.
64. Forwarding note. Every person entrusting any goods to a railway administration for carriage shall execute a forwarding note in such form as may be specified by the central government. And then, my lord, provided that no forwarding note shall be executed in the case of such goods may be prescribed. Number 2, my lord, the consignor shall be responsible for the correctness of the particulars furnished by him in the forwarding note. Then, my section 3, subsection 3, my lord, the consignor shall indemnify the railway administration against any damage suffered by it by reason of the incorrectness and incompleteness of the particulars in the forwarding note. That is important, my lord. Next, my lord, that is learned friend saying received and thing that does thing. A railway administration shall 65. Next section, my lord, railway receipt. In case of in a case where the goods are to be loaded by a person entrusting such goods on the completion of such loading on, or in any other case on the acceptance of the goods by it, issue a railway receipt in such forms as may be specified by the central government. Next, my lord, a railway receipt shall be prima facie evidence of a weight and the number of packages stated therein, my lord. Then, my lord, provided that in a case of a consignment, that is that case, my lord, in wagon load or train load, and the weight or the number of packages is not checked by a railway servant authorized in his behalf, and a statement to that effect is recorded in such railway receipt by him. The burden of providing the weight or the case may be the number of packages stated therein shall lie, and the consignor, the consignee, or the endorsee. That is, my lord, as per.
Also, is not applicable in this case.
My lord, that receipt, my lord. That receipt, my lord.
The railway has granted a receipt. This is when no receipt is granted.
That
when
is
it
the.
is not checked by the railway at the.
Yes, but railway receipt is not the primary, secondary evidence of this, my lord, any consignee, my lord. That is the section said, my lord.
When railway receipt is granted, this proviso is not applicable.
Yes, yes. Then my lord 79, my lord. Section 79, ointment of a consignment on request of a consignee or endorse. A railway administration may, on the request made by the consignee or endorsee, allow the ointment of a consignment subject to such condition on payment of such charges and may be prescribed, and demurrage charges, if any, provided that except the case where a railway servant authorized in his behalf considered it necessary so to do, no ointment shall be allowed of goods booked at owner digs rate or goods which are perishable and are likely to lose weight in transit.
Not applicable.
Yes, my lord. But Your Lordship, kindly come to my report, my lord. That is affirmed, my lord, in the month of June, my lord. Your Lordship, kindly come to, my lord. Page 3, para 3. In order to comply honorable court order, that is a joint program was conducted 17th of January 2023 at 10 hours at Padmapukur Shalimar Motion Weight Bridge, wherein a team of legal metrology officer, petitioner representative named Ato concerned railway officer were present. After given memo to on duty station manager, Padmapukur and several communication block was allowed. After departure of train, Shalimar Ato on the place, after testing of test wagoner, the ointment on the above VP number Ato was completed at Ato inlet from Weight Bridge at about Ato without signing on the ointment report, in spite of several requests and telling repeatedly, my lord. That is also, my lord, important point.
Joint issue on this.
Yes, my lord.
He has no objection whatsoever.
Yes.
But what about the reweighment report?
The legal metrology can say something because
You have a lot more.
I am only highlighted, my lord, section 64, 65, my lord, that regarding receipt part, my lord. And also I am preliminary objection regarding, my lord, if any claims carried forth, it should be go to railway claims tribunal. Railway claims tribunal, because it is a claim.
Similar order has been passed by the division bench. How do you deal with those judgments?
That is true, but that is
Then what is not true?
that is my objection, my lord, because it is a claim, purely claim.
The division bench judgment before the Supreme Court?
No, that is not.
They stare at our face.
Yes, that is not. That I just seen that division bench judgment.
Order has been complied with.
But whether
Supreme bench order has been complied.
Supreme Court prefer or not, I don't know.
The order has been complied with.
That learned friend, no, I'm trying.
You can ask my learned friend to take it. It has been complied. Punitive charges
Because
has been asked to be paid along with the cost
It is a claim.
for negligence on part of the officials, because they have also have the duty to certify that. That is provision I have shown, my lord. Half yearly, their department will personally see, and for yearly legal metrology will do. But they have not annexed any documents that their own department has seen that it has running perfectly. This is what is lacking in the report.
This is, my lord,
আমার তো এটা বলবোই না।
but this is that limit has already crossed, my lord.
Next, the report with your report, the reweighment report undertaken in terms of the court's earlier order. Where is the report?
That is not available, my lord.
This petition is actually on the basis of that report.
Yes, my lord.
Since reweighment shows that your weighbridge was not functioning, the petitioner shall be returned back the punitive charges. You're representing an authority, sir. Where are the documents?
Yes.
For further instructions, or shall I reserve?
So, should kindly give.
Because these documents have been produced by the petitioner.
Yes,
I would like to see your documents.
Lordship, kindly give some time, my lord, 7 days.
No, Lordship, no further indulgence should be given to them, my lord. They have
What
already,
indulgence?
Lordship, report has been filed. They have annexed documents. Lordship, it is,
It is very unfortunate. I don't.
Because all the officers transferred, my lord, that is the problem.
Don't appear to be ready on any of the occasions.
Because of, my lord, many person transferred from their post because of accident, my lord. That is a problem. Really.
these officials,
For you not being ready. The matter.
no, yeah, humbly beseech, my lord, the officials were reprimanded and they were cautioned on the previous occasion because the way they have dealing with these things, and it's a very casual and lackadaisical manner, my lord. They have imposed the cost.
Yes, Mr. Mondo.
Hold the paragraph 5.
Of your report. Paragraph 5 of your report. Yes. Where is the verification certificate?
What's it?
A verification certificate is required to be issued. Where is that certificate? Showing that the weighbridge is functioning, isn't it?
Page 21,
Page 21, annexure P6, R6. What is this? Where is the certificate? This is. This is not the certificate. This is a notice.
not certificate is available, but
This is a notice. Yes?
the letter already issued by the department.
You have referred to a certificate in
Next,
page 3.
What to do?
It is for the legal metrology to determine that the weighbridge was functioning on the relevant date.
Next date I will put it.
So one aspect may I highlight, my lord, from the legal metrology's report, that they have undertaken to verify it after your lordship has passed an order. It is appearing from their paragraph 5. But legal metrology is also silent with regard to its correctness when the incident actually occurred. Because legal metrology has not stated anywhere that when the payment was undertaken, second payment, that the machine was performing correctly or not. Only after your lordship passed an order, they
Position to ascertain that because that was over already.
or my lord, this aspect has been gone into by this division bench because, my lord, there are anomalies in the report. So even after the verification carried out by the legal metrology, anomalies are coming. Then lordship kindly visualize the situation when the incidents are happening outside when the legal metrologies are not present and railways are reluctant to repair it. So my lord, let my learned friend says at least the day of incident it was functioning properly. It's not after the incident happened they have rectified it. Lordship, what they have stated is at page 2, paragraph 5. Lordship, kindly see. Probably my lord, lordship will get the answer from this paragraph. It's a legal metrology's order. Paragraph page 2, paragraph 5.
So on this only I was asking him.
Yes.
Where is this certificate? A verification certificate is supposed to be issued, stating that it has been verified and found to be correct.
Yes, only after your lordship's order was passed.
No, but that is also not there. Where is the verification certificate?
Kindly, lordship, visualize the state of affairs in the railways and the legal metrology. It has to be done by the legal metrology themselves and also by the railway's own department. Railway has failed to produce the corrected fitness certificate. Legal metrology has failed to produce the fitness certificate. And they are disputing my payment, which has been ascertained by the railways to be correct by another wings of the Indian Railway. And for this reason, my lord, the railways officials were penalized for the action. What they did in that matter, my lord, without even intimating the legal metrology, they tried to fix it on their own to cover up their misdeeds. That is the reason cost was imposed. Lordship will not going to find any plausible explanation because the rules are very clear. The manual are there before your lordship. I have highlighted those rules and annexed those rules in the report also, how it is to be carried out. All things are there. Nowhere, neither in the metrology's report nor in the railways report, lordship will find any compliance of the rules. No rules have been indicated even. Lordship, kindly reserve it for judgment, my lord.
Let me reserve it for judgment. Of your report? Yes, paragraph 8.
Fourth line, my lord. Observation sheet containing image. Test one.
Yes, where is this observation sheet? I'm asking for the document. Many things have been written in the report, but where are the
60 readings were obtained. Here it is stated 60 readings were obtained.
Where are they?
60 readings are not annexed. Lordship, kindly visualize one thing. Only on single Lordship exercise that overloading has been detected. Here, kindly see the confidence level of the officers from both the statutory authorities. On 60 occasions, it was taken here and there to get a proper reading. But still, my lord, those reports are not annexed.
Because of shortage of manpower. Every department has very small.
Cannot be the, my lord.
The more you submit on this, the more you are letting your.
That is true, my lord. Sorry, my lord. Sorry.
Down.
Sorry, my lord. Sorry.
Please do not do this.
Lordship, I have no other further to add, my lord. This is.
Do you want to? Yes.
That report will be submitted.
You have already submitted a report stating lot of things without any document.
Certificate.
Yes,
No, relating with the certificate, I call for the officer.
when can you come back? When will you come back?
2 weeks time.
2 weeks.
Mr. Chakraborty's suggestion doesn't help because 2 weeks is still this side of the vacation.
Well, they are dragging this matter, Lordship, since 6 months to 8 months on one plea on the other, my lord. But they have got ample time to rectify their own mistakes, my lord. But they didn't do so, waiting for the Honorable Court's intervention.
18th December.
Lordship, kindly record, my lord, I have submitted my, because I have nothing more to add on this. I have completed my submission.
Or learned counsels for the parties. Paragraph, learned counsel for the legal metrology is respondent number
Number 5.
5. no? Fifth respondent seeks to take further instructions in this matter and submit documents referred to in the report in the form of affidavit submitted. Paragraph, liberty is granted to the fifth respondent to use a supplementary report annexing relevant documents, comma, if required. Paragraph, let the matter appear under the same heading on 18th December.
Yeah, I have completed my submission, my lord.
18 December or 12 days, 20 December.
See, they should have.
It's for the legal metrology to decide, not the authority, not the railways. He has to come back with the report.
They have also to have to annex the report, but they have not annexed any report.
He doesn't want to. So the court will not call.
But the rules is very specific on this, my lord. The commercial manuals.
Please give me a copy of.
Yes, yes, I definitely. Manual is very specific on this, my lord. It has to be done by the mechanical department of their wings.
That is true, my. That is true. Absolutely.
Now he's saying that is true.
Everything is true.
I think my lord friend is suppressing something, because if the report comes, everything will be clear, my lord.
Judgment on admission, I think.
Admission.
Let us see.
Now, Mr. Rai is now, that case is loud mood, but another case, my lord, he has something.
Next.
Item number 505.
Well, in this matter, I can recommend that the report দিয়েছেন বলা in the last occasion the matter was hot report my lord.
Received a copy?
No, I have not got copy.
Letter.
So I have to.
Advance copy.
Yes, my lord, I shall. Sorry, my lord. I shall use the exception, my lord, kindly.
November. Today is 6. क्या उचित ছিল 30 তারিখ হ্যাঁ that is exception. Well, I saw with Mr. Nondi and Mr. Khan.
Yes.
Both parties.
Today.
Sorry, my lord, it is my fault. Otherwise.
So next time I will kindly fix.
After vacation, every matter cannot be kept next.
No, I know. It is not possible, my lord. Well, first week of my lord January. First week of, because matter is pending, my lord, since long.
It is a hearing matter, my lord. Government suffering for pendants of the petition. Government not grant any.
Problem has been created, but
Suffer
I made an objection.
Invited the writ petition.
It has objection, my lord.
Suffer.
Created the trouble. Okay, my lord.
That is a.
Adopted the policy, the route which before, my lord, they extended. We read the objection for introduction. Without considering our objection,
I have seen this.
notification was issued.
I remember.
Yes, these are recorded in the last occasion.
It was introduced without considering your.
Yes.
Yes.
That is my lord. That is the law is well set.
No. Law
Government
does not
has
say.
Extension first.
Yes.
And then,
Extension is process. Extension on process. I am not
already
first process. Yeah. Actually, my lord, the route covered, which is not is the route. May I submit?
overlaps in some.
No.
3 kilometers, but it's a
Only
part of
3
the existing
kilometers.
route, not the new route.
That is the overlapping portion. Overlapping concept is gone after 88 Act has come. Then, my lord, the question of new route, total covered, total. His
Commission
portion,
bypass
his,
Kamal on their own
his
street.
portion is Calcutta station to Hatisala. I remember that. Hatisala, Lordship knows. His permit is Calcutta station to Newtown.
And extra than
That is from
3 kilometers.
that is all 3 kilometers. So what wrong? What wrong in it?
What is the difficulty in considering his application first and then introduce the new route?
Yeah.
There is no difficulty.
No,
but both are
the fill inquiry will be made. Keeping my application pending, the patient.
that is process. That is process.
Yes,
And due to commuters as local demanding that.
Our extension for the interest of the commuters. Only for the interest.
We are not standing in the
intending operator. Vishwa Bangla, he's not
I will.
Mr. Khan, come back with
Yes,
I will extend them if they are due. No problem.
That should be done first, and then.
Yeah, that should be done first.
Report in the form of affidavit submitted on behalf of the state respondents is taken on record. Paragraph, learned counsel for the petitioners seeks to use an exception to the report. Paragraph, let the matter appear under the same heading on 9 January.
Well, by one thing, my lord. After that, my lord, a meeting was held on, my lord, meeting was held on 27th July 2023. As the matter is sub judice, no application will be invited. But secretary invited application to accept the application. So,
No.
on this of the ground,
No, there is a sub judice matter, but there are no grant of permit. In spite of having offer letter, no, we have not done it. That is no question of further. We are only made an.
Next.
Item number 506.
My lord, I appear for the petitioner, my lord. Pursuant to your lordship direction, my lord, the railway has filed the report. It is not the state who has to.
Wanted to file a report. Yes, Mr. Devra.
I'm sorry, my lord. I'm still.
Mr. Ghosh, you have received a copy.
I'm for after copy. Railway is the main party, so kindly direct so that I can see that what is the. Oh, thank you.
You need to use an exception.
Yes, my lord, I shall come back, my lord.
Report in the form of affidavit submitted on behalf of the state respondents is taken on record.
And solve all the parties.
Paragraph, learned counsel for the petitioners seeks to use an exception to the report. Paragraph, let the matter appear under the same heading on 9 January.
My lord, on the last occasion, your lordship, my lord, granted leave to my lord file, my lord, exception to the both report, my lord. That may be that the same may be continued. Yes. Great.
Annual matter.
That will appear
9 January.
Item number 507.
My lord, I beg to appear on behalf of the petitioner. My lord, the matter is relating to issuance of RC cancellation. The petitioner before your lordship happens to be a person who is associated with this transport business. He runs 4 trucks. One of the trucks, which is following the subject matter of read, has.
Private respondent.
Yes, my lord, I have served them.
Affidavit.
My lord, it is basically the matter dispute is against the ARTO. We have.
Be affected if your prayer is allowed.
Nobody will be affected. No, my lord, nobody will be affected. My lord, just because I have added them as a party. Yes, I have served upon them. My lord, they are the drivers and the assistant driver who had died in that incident. If their appearance is required for extra precaution, I have added them. Otherwise, ART, this particular matter has nothing to do with them. Yes, well, I bow down.
There is one private respondent, I find.
Yes, driver.
Who is appearing for the insurance company?
I know.
United India Insurance.
This matter has to be before the motor accident claim time. Otherwise,
my lord, the thing is this.
It's an accident claim.
Yes, my lord, it is accident claim. It is about, my lord, it is just a matter of 1 minute, my lord. It is just request RC cancellation.
since we are we want the insurance claim amount, my lord, it is a mandate without issuance of RC cancellation by the concerned ARTO under which it is registered that insurance amount cannot be disbursed.
Under which provision I cancel the RC book?
My lord, that is the reason we have made a my lord, that is the reason we have made a representation before the concerned ARTO.
But what's the problem? Cancellation of RC?
My lord, I have to check.
Of an accident? That's your case.
Yes, my lord. It is just issuance of the that
Cancelled on, and even if it is cancelled, it goes before the MSCC tribunal, I think.
my lord. The thing is this. I mean,
Has to be made an application before the claim tribunal, where the learned judge
my lord,
passed
it
an
has
order
nothing.
cancel the
For cancellation of RC.
Yes,
cancellation of
RC.
RC. No,
Yes,
no, no question for asking the insurance.
What's the provision
Policy.
for cancellation of RC?
My lord, may I come back with?
It's because I do not know, and this person is served, Pankaj Kumar Mishra.
ছত্তিশগড়ের গাড়ি
না ছত্তিশগড়ে অ্যাক্সিডেন্টটা হয়েছে
হ্যাঁ।
গাড়ি ব্যারাকপুরে
The private respondent has not been served. Item delivered to the sender. Please check the track report. And insurance company has also not been served. Dispatched to BO, beat office. Sorry.
let me sub can come again.
You find out the subsequent track reports. Maybe it is served thereafter. I don't.
Yes,
And the provision.
I will come up. I will come up.
Since service upon respondent numbers 4 and 6 is not complete, comma, let the matter stand over till 16 January.
My lord, the problem is this. I before submitting a lordship, I just sharing my piece of my mind. That thing is this. I have gone through the provisions. My lord, there is no specific provisions for RC cancellation. It is under the all what can be found is that it is under the ARTO, and it is the concerned ARTO who can issue that, subject to the condition that all the premiums that is required that has been paid.
This is one thing. Cancellation is another thing.
Yes, my lord. That is the thing, my lord.
There is no provision. The court cannot direct. Simple.
Yeah, my lord.
Please go through this.
I will, my lord.
If I feel this is not maintainable for this court, come up. I'll mention the matter. I'll take it up.
I'm extremely grateful, your lordship.
কবে আসবে বলবেন?
Next.
16 January.
Item number 508.
My lord, the writ petition and the annexes have been served on.
Serve the Mr.
Yes,
Debra-
yes, ma'am. It has been served, and this is the affidavit of service.
Mr. Debra is appearing. Yes.
I'm appearing. I'm appearing.
Uh,
What's the matter about?
In this matter, Mr. Chakraborty is appearing in person. He mentioned in the morning that he is on his legs in another court. So, Lordship, praying for not today can be taken up on, if Lordship pleases, tomorrow or next Wednesday
Come back after vacation.
after vacation. Thank you.
Give it of service. On prayer of the petitioner, the matter is adjourned. Paragraph, let the matter appear under the same heading on 15 January.
15 January.
বাকি টাইম না টাইম টেবিল কন্টিনিউ হয়ে যাবে আমি বলে দিচ্ছি ওকে
Item number 509.
I am for the petitioner, my lord. I am for the state, my lord.
My lord, Mr. Sonos Kumar Roy is appearing for the private respondent, my lord. He has not come personally. Yes, my lord.
You are there.
Start কর
Yeah, my lord, the petitioner has made an objection against the private respondent, my lord.
You are a private respondent.
Yes.
I also requested me at night, my lord.
My lord, kindly take it not.
Consider the representation only.
My lord, he has gone to his medical checkup.
I am praying for a consideration of my,
That's why not today. Come back on time.
Yes.
Keep your
Next.
Item number 510.
I am appearing on behalf of the
Lord, I appear for the petitioner, my lord.
Railways,
My lord, my learned friend is appearing, my lord.
railways.
It's only the railways, my lord. This is, my lord, a case, my lord, of extreme high-handedness on the part of, my lord, the respondent authority, my lord. I have entered into an agreement with the railways for parcel van. My lord. After that, I found there was a clause, my lord, 5 minutes and 10 minutes of loading, unloading. After that, my lord, I made an application to them that kindly grant me loading where 5 minutes is also available. They did not consider, my lord, especially, my lord, this part of railway, because the South Central Railway has already granted. I filed a writ petition before your lordship. The writ petition was adjourned on 5 occasions at the instance of, my lord, the respondents. During pendency of the writ petition, they come up with a termination letter before your lordship. Then, my lord, I withdraw the writ petition from your lordship's order, my lord, and then we have filed this writ petition challenging, my lord, the order of termination. I will straightway take your lordship to the order of termination, because that is, my lord, what is important as on date. My lord. The order of termination is, my lord, at page 78. It says, my lord, termination of lease contract for 24-ton space in LVVH train number 18045 and 18046, my lord. Kindly come, my lord, the subject is not in reference, my lord. You'll see, my lord, neither the writ petition nor, my lord, any of the representation is, my lord, considered. The order says, my lord, the UL lease 24-ton space in LVPH by train number 18045, 18046, Shalimar Hyderabad East Coast Express in Shalimar to Hyderabad on round trip basis on 6 days in a week for a period of 5 years with effect from 24/7/2022 to 23/7/2027 at a per round trip freight of rupees 2,18,000 for first 3 years with annual escalation of 10% lump sum lease freight for 4th year onwards. CSP SHM via his letter under reference has intimated that Sri Shiva Prakash, Nurale leaseholder of LVVH by train number 18045, 18046 commenced the lease operation at Shalimar on 24/7/2022 and the said leaseholder successfully loaded LVVH till 30/12/2022. After paying the due freight on 29/12/2022. From 31st/12/2022, leaseholder has stopped the suspend the lease operation. Provision of the agreement states under para 8.4, if the leaseholder after commencement of the loading fails to operate the contract continuously for 10 days without giving any notice, his contract will be terminated and security deposit forfeited. The next clause they rely on 25.1, my lord. Leaseholder shall have the right to terminate the agreement after serving 60 days notice to the railway administration. However, leaseholders shall not be allowed to terminate the contract before 1 year, 10 months plus 12 months notice period. In case of any contract, whether it is on the short term or long term, in case it does not does so, his security deposit shall be forfeited and shall be debarred from entering into any tender for next 2 years, but he shall be allowed to operate the existing tender for other trains, if any. Now, my lord, leaseholder can give notice for termination of contract after completion of 10 months. Thus, 10 months plus 2 months notice period equal to 12 months period will be completed. After completion of 1 year period, the leaseholder can be allowed to quit the contract. In such cases, security deposit shall not be forfeited. For the above said breach of the contract on your part, your lease agreement that for 24-ton space in LVPH by train number such and such, Shalimar is terminated with immediate effect. Security deposit of 35,51,397 deposited by FDR number such and such dated 4/7/2020 in favor of FSCO Southeastern Railway is forfeited and you were debarred from entering into any contender for next 2 years. Now, my lord, the prima facie on the face of it, the railway has, my lord, relied on 2 clauses of the agreement which they have quoted. My lord has seen, my lord, clause 8.4. It says, my lord, if I do not operate for more than 10 days without giving them a notice, then only, my lord, the 8.4 will apply. My lord will kindly take, my lord, page 80, my lord. They say I have stopped operation from 31st December 2022 in the rate. This is the letter on 30th/12/2022, my lord, page 80. My lord will kindly come to the last page, 81. Last line, my lord. Despite
I am unable to continue the above said lease person when contract from 30/12/2022. So, my lord, I have given them a notice that I will not be able to continue. Therefore, my lord, in my humble submission, the clause 8.4 will not attract in this case. So, my lord, the next what they have said, my lord, the termination. The 25.1, my lord, will apply if I terminate the contract. My lord, the letter which I have given on 30/12, it does not say about the termination.
Provision under the act where you are entitled to a notice prior to termination?
Yes, Milord, they are terminating, Milord, where, Milord, there is a breach on my part. They say there is a breach on my part. Without notice, they can terminate. And, Milord, they can also, Milord, in normal cases, can terminate by giving a 30 days notice where there is an operational expense. That is not the case they have made out. Since, Milord, during my writ petition, Milord, their issue was pending, and, Milord, I have given notice. Without considering my notice, they straightaway issue, Milord, the termination notice, relying on two clause, Milord, which in my humble submission does not apply to my cases. Because I have seen, Milord, 8.4. Well, there has to be, unless there is a notice that doesn't apply. And they have not come up with any letter saying that I am terminating before 1 year of service. That was nothing on record. And one important aspect, Milord, they have debarred me from participating in future tender. Now, Milord, the law says that they cannot debar me without giving an opportunity of hearing, Milord, before they, Milord. I am carrying, Milord, the judgment of the Supreme Court, Milord, the Erusian equipments, Milord. It is reported in 1975, 1 SCC Supreme Court cases, page 70. Milord, paragraph 20 is, Milord, where, Milord, it's a larger bench of the Honorable Supreme Court, Milord, decide that in case of blacklisting, there has to be a notice, Milord. I should be heard. Para 20, Milord.
That is settled law.
Yes, Milord. Blacklisting has the effect of preventing a person from privilege and advantage of entering into lawful relationship with the government for the purpose of gains. The fact that disability is created by the order of passage indicates that the relevant authorities to have an objective satisfaction. Fundamentals of fair play require that a person concerned should be given an opportunity to represent his case before he is put on blacklist. Now, here, Milord, admittedly, no notice issued. And, Milord, the fact that, Milord, I was pursuing my writ petition will apply from your Lordship's order, Milord, which are appearing, Milord, page 73 and onwards, Milord. The first day they have sought for an adjournment. Page 73, the first day when I wanted to move, they sought for an adjournment, Milord, the railways. That is on 23rd 11/2022. The next day, Milord, 2nd January, the writ petition was moved, Milord. They sought for an Milord, the leave to file a report, Milord. Milord, then 25th January, they sought for extension of time to file a report. Again,
The petition has been disposed of?
no, that was pending.
That was withdrawn.
Withdrawn subsequently. 25th of January, Milord, they are seeking, Milord, an extension without disclosing to your Lordship that they have terminated on 12th of January. And then again, Milord, 7th of February, they are seeking, Milord, an extension to file a report. And when, Milord, this report was served on 28th of February, your Lordships, I came to know, Milord, that it has been terminated. And thereafter, Milord, the withdrawal order, Milord, Lordship will find at page 79. 12th July, Milord, I have withdrawn the petition, Milord, in view of this termination has coming into effect. So my humble submission before your Lordship, Milord, this termination letter on the face of it that cannot stand, Milord, because the two clauses Railway has invoked cannot be made applicable in these clauses. And one more respect, they could not have blacklisted me without granting me an opportunity of hearing.
Yes, Lordship, in this matter, Lordship, kindly come to page 80. What is his representation? Lordship, he said that kindly come to page 81. This is my last and final representation to the Kharagpur Division Commercial Department, Southeastern Division, such and such from 30th 12/2022 onwards. I am going to stop the lease parcel van loading and unloading, stopping flying off one day advance of Shalimar Railway Station till the Kharagpur Division Commercial Department, such and such. If the Kharagpur Division Commercial Department and Southeastern Railway Commercial Department are initially not granting me the above said en route station loading and unloading permission. I humbly requested the commercial authority of the Kharagpur Division Southeastern Railway kindly refund my security deposit amount of such and such, and thereafter further I am unable to continue the above said lease parcel and contract from 30th/12/22. Lordship, he on his own declared that he do not want to proceed with the agreement.
No, that is not the fact at all.
Yes, Lordship. Kindly further I am unable to continue.
So this is a notice.
And Lordship, kindly the said letter was
a notice in compliance with 8.4.
Yes, Lordship. This is the letter is on 30th/12/2022, and the earlier matter was filed by him in the month of November. No, Lordship, at the time of hearing, they never said that this letter was written by them. Before your Lordship.
Subsequent.
No, Lordship. This is 12/7/20. This is 30th/12/2022, and the matter was withdrawn on 20th February 2023. In the matter 6 or 7 times, the matter was heard by your Lordship.
Did you inform the court that there was a termination in the meantime?
And thereafter, Lordship, I don't know earlier advocate what they done, but in this matter, as per his letter, the agreement is he on his own discontinue the agreement.
Not, madam, that is not the that is not the interpretation.
And Lordship, and now I want to file my affidavit in opposition. Otherwise,
at all. I'll pass an order here and now.
No, Lordship, kindly.
No affidavit is
It can't
required
be.
in this matter.
It can't be. Lordship, kindly come to the agreement. At first come to page.
I can at best allow you to come back with a report in the form of an affidavit.
Lordship.
My lord, only one relief, my lord, since my lord has seen my lord over there, kindly direct them to secure the money before this court, my lord, then they file it. Because they have forfeited. My bank account has been debited. Now they are enjoying the money, and I should, my lord, that should be kept in this court so that, my lord, that earns some interest here.
No, Lordship, the agreement was gone, and now the new agreement
stayed at till
My
certain period. Affidavit of service. The order of termination.
And Lordship, kindly see one thing. 8.4, page 31. 8.1. If the leaseholder after commencement of loading fails to operate the contract for 10 days without giving any notice, his contract will be terminated and secured. His letter was on 30th/12 December, and the termination letter is 12/1.
So
it is there are 10 days, Lordship. 10 days he regularly not.
Is that the interpretation?
10 days he never loading and unloading as per agreement. He should loading and he should running business, Lordship.
Stops loading, unloading without notice, you can terminate. He has given a notice and then stopped loading, unloading. So 8.4 is not applicable at all.
Well, Lordship, he on his own told that I do not will you carry out my business.
I'm sorry, madam, that is not the interpretation at all. If you want to come back with a report, you can. I'll allow you. Since prima facie petition has to be allowed. Authorities, this is very, I mean, this is.
I will file my report.
Issued by the assistant commercial manager or the senior divisional commercial manager, Kharagpur, on 12th January 2023.
1975, one is
held in the report.
1975, one SCC, page 70. 7 bill.
Paragraph learned counsel for the petitioner submits that the grounds on which the contract has been terminated is not are not applicable the petitioner, since the petitioner has stopped loading operation upon service of notice to the authority, and also the petitioner has no intention of terminating the lease from his end. Paragraph na এর সাথে একটা line করুন. Learned Counsel has placed reliance on the authority in Messrs. Erusian Equipment and Chemicals Limited versus State of West Bengal and another, reported in within bracket 1975, volume 1, Supreme Court cases 70, in support of his contention. Paragraph, Learned Counsel for the respondents seeks to submit a report in the form of affidavit in this matter. Paragraph, let the matter appear under the same heading on 10 January.
Great.
Hearing matters.
For hearing, item number 523.
My lord, very outset, I submit today, I will oppose. This is
My lord.
23rd day adjournment.
Because my lord knows
What will be the reason?
whatever, my lord, this
Three
week, my lord,
passed.
because my lord leading this matter,
Mr.
Advocate
Ananda
General
Mitra, then
already
Mr.
leading
Kishore
this
Datta, then
matter,
Mr.
my lord.
Mukherjee, then again.
My lord, within 2-3 days, my lord, it will be solved, my lord.
No.
My lord, kindly fixed.
What do you want to solve?
Learned Advocate General,
No,
my lord,
no.
leading this matter, my lord.
There and on his ground times, 3 advocate generals, or Mr. Ananda Mitra, Mr. Kishore
My lord,
Datta, Mr. Gopal Mukherjee. 23 days, I have never opposed. What is this? There is a limit of everything. We also have client, we have to answer to them.
Let them continue. তুই প্রত্যেকটা পরে বলবি, তুই রেকর্ড কর, নোট কর।
Why is the appearance of advocate necessary in this matter?
I don't know, they say, they prayed for it.
No virus is
No, nothing. And my case is 5 minutes, not more than that.
Because, my lord, this matter, my lord, leading with Learned Advocate General, my lord. Advocate General is required, my lord.
Why is his appearance required? He is a busy man. His appearance will be required in certain important matters, isn't it? Their virus is challenged, etc. Why is why is he required in this matter?
My lord,
Why do you want to disturb him in this matter?
they complete, my lord, they complete their argument, my lord. I note it's, my lord, next day, my lord, I reply before your lordships.
That will not really help.
No, again,
Can be done on a single day, I think.
I will take not more than 5 minutes. This dispute has been resolved by a competent court of law. Again, try to reopen it. By this process, they have to challenge it. It's not a very lengthy argument, question of law involved, nothing.
You are appearing in this matter.
Ah.
Shall we start?
My predicament is only that I was led by the Lord Advocate General.
Who is no, none.
Who is none?
क्यों नहीं तो?
You are an efficient, competent leader yourself, Mr. Siddiqui. Why do you need to be led as
কি করব? স্টার্ট করো।
স্টার্ট এন্ড একসঙ্গে হবে, ছোট্ট মামলা, তুমি ভালো করেই জানো।
না বড় মামলা, আমার জন্য আমি নেব টাইম।
My lord, only one thing, let them, let them start. Mr. Basu has already decided that he will start and end. Lordship will continue, though I am the requiring authority, but I have certain substantial submissions to make. Let him complete, I'll start.
your affidavits are there?
Yes.
Everything is.
Well, I'll be submitting on the law points, let him complete. The state will reply, I have certain submissions to.
Has made submissions. I have taken a note also on the earlier occasion.
Very short point, very short point. A coordinate bench decided that this property is not included in the land acquisition proceedings. In spite of that, my land has to be, my lord, interfered with. This is the case. Should I open or, my lord, again, my lord, really, in this matter, I am really disturbed.
Submission is almost complete. I have a note of it.
Yes, completed. Then they say, prayed for adjournment.
Mr.
And seen the day when it was concluded, long back.
My lord, I will not make any excuse any day your lordship pleases, my lord, I can come back. Because even if the learned advocate general
Any
know
day?
that, well, any day your lordship pleases, my lord, I can come back.
It appears to be a short issue.
Short issue, my lord, but we have much.
My lord, kindly do not make up your lordship's mind that it is a short.
Because,
That is my
because,
submission.
because my learned senior friend is my lord, my caustic.
Make it longer.
Or I want to save myself to my argument.
Yes, you have the liberty. Yes. To make the short issue long.
When there is nothing, it has to be made long.
And I have been taught most of what I know or do not know by Mr. Basu.
No.
That includes the adjournment part also. Mr. Basu. Be careful.
Yes, I know that. Next is this.
No, but even if I pray for in any case, I'll not say that he has taught me that.
He'll come back on 8th January. And please be ready on the next occasion.
Can I pass an order?
I request all of
My
you.
lord, I am ready. Order pass.
State apparently allowed as a last chance. Can't help.
Or kindly pass
I'll
an
come
order.
back on it.
Several adjournments. Learned counsel for the state respondents seek accommodation. Paragraph as a last chance, the prayer is allowed. Paragraph, let the matter appear on the same meeting on 8th January.
And I hope it will retain its position.
2017 matter has to.
8th January. retain its position.
Item number 524.
Mr. Bian, you are successful, huh?
আমি এখনই
You
argument.
are successful in my training.
This is not fair, my lord. I could have made my arguments right now. আমি জাজমেন্ট নিয়ে এক্ষুনি করে দিতাম আমি বাজে কথা বলছি তুমি আরে 8 থেকে কিছু নেই তো
টপ বলা নেই 17 তে এমনি টপে আসবে
তোমার মামলাটা কবে ফিক্স
এমনি
হয়েছে
উপরে আসবে আলাদা করে top হবে।
Your lordship thought this matter on various occasions earlier. And now, my lord, learned advocate of the state has been learned advocate of the state.
I've been engaged in this matter, my lord. Unfortunately, it's a 2017 matter.
Yes.
It's a 2017 matter, my lord. Someone was there earlier who was engaged in this matter. Now, since he's not there in the panel, I've been engaged. I'll be needing some instructions to argue
So you're not ready to do that? You have to sit.
for the state.
For the state, show it to them.
আপনি আছেন তো তাহলে এটা
You're a good.
কি হয়েছে এটা
আমি অ্যাপিয়ার করছি
তাহলে আমাকে দিল কেন
তুই থাকো
আমাকে দিয়েছে কেন
তুই থাকো তুই সাবমিশন
I have been,
আমার জুনিয়র গভর্নমেন্ট অ্যাডভোকেট মিস্টার ব্যানার্জি প্রিপেয়ারিং
The state had also made submission on the earlier date. Petitioner had completed
তাহলে
the state submission.
আপনাকে
was
এনগেজ
also
করে
made.
যেমন করেছে কি করবো তাহলে কি
থাকো না তুমি তুমি থাকতে বান করছি বান করেছি তোমাকে এনগেজ করে
আমার কাছে ইনস্ট্রাকশন নেই তো আমি যদি ইনস্ট্রাকশন আপনার কাছে থাকে তাহলে আপনি বলে দিন
স্যার আরম্ভ করুন
Unfortunately, both of us have been engaged, but since I don't have the instructions, I believe my learned senior friend has the instructions. So let him argue. Let him argue.
স্যার বলুন স্টার্ট করুন আর কি বসো 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 my lord your lordship heard this matter on various occasions on our
Taking notes also, if you want to recapitulate, you can.
and at that point of time Mr. Swapan Datta was appearing.
Yes, yes.
Now
State
Mr.
is
Banerjee is appearing. Your lordship, should I begin from the beginning?
Just the point.
But
I have
crux of the point.
I have
that
taken a detailed note of your submission.
I am the owner of a property. My property cannot be taken away by anybody in violation of Article 300 capital A of the Constitution of India. In the affidavit in opposition, it has been stated that Panchayat Samiti handed over my property to the executive engineer to construct water plant. I do not know when my land was taken, who has taken, why is taken. Question arose with regard to delay. Your lordship remembers I submitted before your lordship two judgments of the Honorable Supreme Court,
Yes.
where delay of 42 years also condoned. I am an illiterate person of a particular remote village at Latabari, Jalpaiguri.
And you have said this is a continuing cause of action.
Then, my lord, the affidavit in opposition, the Panchayat Samiti said that Panchayat Samiti has no power to acquire the property under the law, under the Land Acquisition Act. It is a land acquisition officer who is competent to acquire the property.
Absolutely.
We wrote to the government, Land Acquisition Department, where, when and how my land was acquired. The reply came that it was not required and it was not acquisition by the government by any process. Then we took the valuation point from the local register of stamp and registration department and stamp revenue. They said my property will be valued at 56 lakhs. Why not? And another report came subsequently 60 lakhs and odd. On the last occasion, my learned friend Mr. Shobhan Gupta took a point that it is a central government scheme. So 5% of the cost of the water scheme has to be paid by the beneficiaries. So now he further said, annex the document the Barwadi committee of the local area.
Sir, beneficiary committee.
Beneficiary committee, Barwadi. Beneficiary committee constituted committee where I am not there. I was not informed who has the constituting the beneficiary committee, who is all this.
Sir, he will reply then again. He will reply.
No, my lord, I do the judgments I will cite.
Other matters released for the day.
Then, my lord, the judgment.
Excellent, sir. Madam, excellent. So, Kaku, bolo, excellent. One of the last matter which your lordship fixed, Mr. Shoptang, lordship has fixed it on 8th. Kindly even if you record 5th is on 7th, well, 8th I will be in difficulty. 7th, 9th, any day. I'm not asking for an adjournment, but 8th I will be in difficulty. Because I don't want to come back and pray again. If lordship can fix it on 7th also, I have no difficulty.
I will not come to court. It's a Sunday.
Oh, I'm sorry.
It can be on 10th.
Mr. Basu is running away.
For my darling.
No, I will not. Mr. Basu is there. I will not inform.
He is after and sending me there.
Malad, he is junior. Malad, on 8th, I will tell you, on 8th, I do not want to come back on 8th and again pray. Malad, because I will be in difficulty on 8th.
But
Mr. Basu is here. He is junior. Malad, kindly do not. I am deeply.
Yes, continue. Please.
With regard to beneficiary committee,
Other
questions.
এত কথা হচ্ছে, I'm not able to hear.
এটা হচ্ছে, শোনা যাচ্ছে।
Please wait for 2 minutes. I cannot hear. You have a very soft voice and there's too much of commotion in the court.
Other matters are released.
Other matters
Other matters released for the day.
All other matters are released except 524.
This matter is being heard before your lordship today on exchange of affidavits.
Yes, it's all recorded.
On exchange of affidavits.
It's all recorded. Yes.
We have filed this application for compensation to the tune of rupees 56 lakhs or 60 lakhs or whatever amount suits your lordship. But only submission I am making before your lordship, there cannot be violation of Article 300 capital A. And there is no question of delay to be considered in this particular litigation in view of the judgment of the Supreme Court. Supreme Court laid down the law in which cases delay will be fatal, in which cases delay will not be fatal. And second point taken by the government, beneficiary committee. Beneficiary is not a statutory authority. This is not an authority under the Land Acquisition Act.
Yes.
So it cannot come into the picture to destroy my right of property under Article 300 capital A. Now the judgment which I have cited before your lordship Vidya Devi, you also kindly consider the judgment. 2020, Volume 2, Supreme Court cases, 569.
Yes.
My lord got it, then I will make my submission. 2020, Volume 2, Supreme Court cases, page 569.
The name of the party?
Name of the body, Vidya Devi versus State of Himachal Pradesh. I not got it, or I will give you copy.
They are not marked actually.
Copy that to the. I'm giving copy.
No, you have given a bunch with your written argument. But I have.
No.
It's
No,
not in
this
the
is not in the
format.
bond. This is not in the bond. One of the kindness. My lord kindly comes to paragraph 3, 11, 12, and 13.
Vidya Devi. It's there.
Paragraph 3.
Paragraph 3, yes.
3. Now, paragraph 2, important. The respondent state took over the land of the appellant in 1967-68 for the construction of a major district road, being the Nandawan Sujanpur Road, a major district road, without taking recourse to acquisition proceedings or following the process of law. The construction of the road was completed by 1975. The appellant, before being an illiterate widow, coming from a rural background, was wholly unaware of her rights and entitlements in law and did not file any proceeding for compensation of land compulsorily taken over by the state. Herein, state has not taken over the property. Beneficiary committee. Now, my lord, kindly comes to paragraph 11. Paragraph 11. The appellant has filed the present appeal before this court, to challenge the judgment dated 11/9/2013, passed by the passed in the writ petition, order dated 13 May 2014, passed in the review petition. We have heard the learned counsel for the parties and perused the record. The appellant was forcibly expropriated of her property in 1967. When the right to property was fundamental right guaranteed under Article 31 in Part 3 of the Constitution. Article 31 guaranteed the right of the private property which could not be deprived without due process of law and upon just and fair compensation. The right to property to be a fundamental right by the Constitution for 44th Amendment in Act 1978. However, it continued to be a human right in a welfare state and a constitutional right under Article 300 capital A. Two rights. The Constitution, Article 300 capital A provides that no person shall be deprived of his property save by the authority of law. State cannot dispossess a citizen of his property except in accordance with the procedure established by law. The obligation to pay compensation, though not expressly included in Article 300 capital A, can be inferred in that article. Then paragraph 12(3), my lord, your lordship has seen the judgments quoted. I am not taking your lordship time because that point was elaborated by the Supreme Court. Now, my lord, kindly comes to paragraph 12.8. The contention of the state that the appellant or her predecessor had orally consented to the acquisition is completely baseless. We find complete lack of authority and legal sanction in compulsorily divesting the appellant of her property by the state. In a democratic polity, government by the rule of law, states should not have deprived a citizen of their property without sanction of law. Reliance is placed on the judgment of this court in Tukaram Kana Joshi versus MITC, wherein it was held that the state must comply with the procedure for acquisition, requisition, and any other permissible statutory mode. State being a welfare state governed by the rule of law cannot arrogate to itself a status beyond what is provided by the Constitution. 12.10. This court in state of Haryana by Mukesh Kumar held that right to property is now considered to be not only a constitutional or statutory right, but also human right. Human rights have been considered for realm of individual rights, such as right to shelter, livelihood, health, employment, etc. Human rights have gained a multifaceted dimension. We are surprised by the plea taken by the state before the High Court that since it has been continuous possession of the land for over 42 years, it would amount to adverse possession. The state, being a welfare state, cannot be permitted to take the plea of adverse possession, which allows a trespasser or person guilty of tort or even a crime to gain legal title over such property for over 12 years. The state cannot be permitted to perfect its title over the land by invoking the doctrine of adverse possession to grab the property of its own citizens, as has been done in the present case. The contention advanced by the state of delay and laches of the appellant in moving the court is also liable to be rejected. Delay and laches cannot be raised in a case of continuous cause of action or if the circumstances shock the judicial conscience of the court. Condonation of delay is a matter of judicial discretion, which must be exercised judiciously and reasonably in the facts and circumstances of the case. It will depend upon the breach of fundamental rights and remedy claimed, and when and how the delay arose. There is no period of limitation prescribed for the courts to exercise their constitutional jurisdiction to do substantial justice. Then, my lord, paragraph 12.13, 12.14. Now, paragraph 13, I am conclude by paragraph 13, my lord, kindly see. In the present case, the appellant being an illiterate person who is a widow coming from a rural area has been deprived of her private property by the state without resorting to procedure prescribed by law. The appellant has been divested of her right to property without being paid any compensation whatsoever for over a century. The case over a century, you will also kindly remember. The cause of action in the present case is a continuing one, since the appellant was compulsorily expropriated of her property in 1967 without legal sanction or following the due process of law. The present case is one where the demand for justice is also compelling, since the state has admitted that land was taken over without initiating acquisition proceedings or any procedure known to law. We exercise our extraordinary jurisdiction under Article 136 and 142 and direct the state to pay compensation to the appellant. Now, my lord, and direction was given to give them within 8 weeks. Now, I am not taking your lordship time. Then another judgment I have cited before your lordship, 2022, volume 7.
SUVRA, yes.
My lord, my lord. Herein, my lord, I only rely upon paragraph 9, 13, 14, 16. Now, my 2022, volume 7, Supreme Court cases, page 508. My lord, with regard to their affidavit, this is on question of law. With regard to their affidavit, they, in their affidavit, this is a very shocking affidavit. Kindly see, my lord, their affidavit. One SUVRA Dhar claiming to be the executive engineer, filed an affidavit in opposition. নোটটা খুলে দেখে এটা ছেড়ে দিন। Kindly see, my lord,
Give me a minute.
Subrata Dhar.
Yes.
Subrata Dhar. My lord, got it? Yeah. My lord, now paragraph 4.
Yes.
Accordingly, piped water supply scheme for Uttar Lathabari under Kalchini block, district Jalpaiguri, now Alipurduar, under the said scheme was mooted. The Pradhan of the Lathabari Gram Panchayat, one of the members of the beneficiary committee, by his memo dated such and such 1999, apprised the executive engineer, investigation division, public health engineering directorate of land for headwork site being plot number 355, measuring 33 decimals, owned by Srimati Sucharita Rai. This is my property.
So this is admitted.
Pradhan earmarked my property, says no, take that particular land for water supply. Then, my lord, paragraph 8. Later, it transpired that the beneficiary committee could not raise funds and instead decided to forego the land as aforesaid for the said scheme. How? Beneficiary can forego my land. Beneficiary, some political party. So, no, I don't care. Your land is taken by us at that point of time. Forgo. How they can forgo? Then this is his affidavit. Second affidavit has been filed by one Dinesh Sarkar. Dinesh Sarkar claiming to the land acquisition officer. Dinesh Sarkar. He is a land acquisition officer, additional land acquisition officer.
Dinesh Shankar. Dinesh Shankar.
Yes, now Allah kindly comes to paragraph 2. Paragraph 2. It appears land acquisition proposal for water supply scheme Uttar Lathabari was submitted by the executive engineer Jalpaiguri by memo dated 2012 along with some connecting documents. On receipt of the same, special land execution officer Jalpaiguri has requested the recording body to submit copy of the cabinet approval of the state case for processing of the proposal, but thereafter no correspondence was made by the executive engineer Jalpaiguri division. So no acquisition case was initiated from this end. This is I am not referring to any other paragraph. Then our affidavit reply. One supplementary affidavit has been filed by Bikram Biswas,
Yes.
claiming to be the assistant engineer. He said, Bikram Biswas.
Yes.
Paragraph 3. I say that innocent writ petition was filed by the writ petitioner in the year 2017, entirely on the alleged ground that the land of the petitioner this is not, this statement has no merit.
I think you
I'm
refer
on paragraph 5.
to paragraph 8.
Further say, sorry. By further initiation for spotting out the land for the said water supply project was started in the year 1999. When the land of the petitioner was identified intimated to the state authority by the Pradhan of Lathabari Gram Panchayat being one of the members of the beneficiary committee. What is memo number to appraise the executive engineer? Right, the said land was handed over to the state authority. Kindly see the very important line. The said land was handed over to the state authority for the said water project by the beneficiary committee with the knowledge and consent of the petitioner in lieu of 5% with the knowledge and consent. What is the document? With the knowledge and consent, there must be some document executed between me and the state government. What is the document? Wrong statement has been made by this particular person. Then, my lord, the concluding portion of paragraph 9.
Yes.
The silence of the petitioner in not raising a dispute or objection to the construction of the pump house spread over for 12 years shows her acceptance of project. That means adverse possession, which has been negated by the Honorable Supreme Court. I am not reading other paragraphs. Then another affidavit has been filed by Aruna Pariyar.
Yes.
Aruna Pariyar. This is the last affidavit. Aruna Pariyar.
Aruna Pariyar.
My lord. Paragraph
Sabha
3,
Pati.
paragraph 5.
Yes.
My lord has noted down everything. No records have been lying with regard to the alleged acquisition of the land of the petitioner in the office of the Panchayat Samiti. It is fairly to be clarified that Panchayat Samiti, Sabhapati are not empowered under the land law to acquire any private land. This is myself. So my submission before your lordship, I am entitled to the compensation, and with regard to valuation of the compensation, I have given the government documents that your lordship will be pleased to find at page 53, page 51. Kindly see the read petition.
Yes, yes.
I am giving a lordship. Nota করে দেখে দেবো paragraph কত দিয়েছি page 51 দিয়েছি page 51 page 51 and 50 kindly comes to my lord page 51.
Yes.
My lord, kindly see page 52. This is the valuation. Page 51. Kindly see page 51. Sorry. Kindly see Government of West Bengal, Directorate of Registration and Stamp Revenue, Tushar Gandhi Saha, Thana Sadhu West Bengal, stamp duty,
60 lakhs and all.
stamp
60 lakhs and all.
60 lakhs, and second document at page 57. 57. There is also another document. আরেকটা কত কিছু কি বলে দেখাও না তুমি ব্যবসায়ী টাইম নষ্ট হচ্ছে তো
This is a representation. Representation. Page 33.
33
33.
কি
Page 33 বলছি।
মোট 33 কি বলছে ও কিছু জানে না পড়াশোনা করে আর শুনেছি
Page 43.
হ্যাঁ
Page 43.
43 page 43 my lord. Another assessment slip my lord, Government of West Bengal, page 43. It was done, kindly see my lord, the reference of my land. Also, kindly see RS 299, Fortier number 409 by 1, Sahan 23 decimals,
This is in 20.
and it has been valued at 56 lakhs 35,000.
It's a
My lord,
outer থেকে কম আর
then my lord,
next is 60 lakhs something. This is 56.
so now my lord, my last submission before your lordship. the we have filed the writ petition in 2017. 2017.
Yes.
We made the correspondence with the government. Kindly see, my lord, last annexure page 40, page 49, 49.
Yes, that's the representation.
There is a 2015,
49.
49,
Yes.
2015. We came in 2017. 2017. So, my lord, and on the basis of the Supreme Court judgment, I am entitled to come within 42 years because I am irritated.
That's all? Yes, respondents. I find written notes of argument from the side of the state.
It's already been filed as it appears, my lord, from my report, my lord.
The only thing which is to be taken into account, my lord, that the beneficiary committee, which was formed for acquiring the land of the petitioner, the beneficiary committee has not been made a party to this writ petition, my lord.
Necessary?
My lord, because they are the one who has acquired. He's the Savapati and the Gram Panchayat Pradhan, my lord. They were not made party to this. They are the ones who will make the payment made to the petitioner, my lord, not the land acquisition, my lord. But that can be done, my lord. That's up to your lordship, my lord. I'm not disputing that, my lord. If they are entitled to the amount, my lord, they are certainly entitled to the amount. I will not come into the way of that, my lord.
Case is more or less admitted.
My lord.
The land was taken away.
Land was taken away, my lord.
There was no acquisition. A pump house has been
My lord, my lord,
constructed there.
my lord.
No acquisition, no compensation. These facts are
These
admitted.
facts are not disputed, my lord.
Also, the Sabhadipati has filed. He was there.
My lord, I do not find. Savapati file করেছে affidavit. তাহলে কি যখন করেছে তাহলে ডাইরেকশন ও করুক করে।
So I reserve it for judgment.
Sir,
17 matter.
because well, these are the things which I will not come into the way of the compensation, my lord. If the land has been acquired, my lord, they must be compensated.
The judgment of the Supreme Court which says that it has to be treated as deemed acquisition.
Certain.
And compensation
Yes.
along with solatium, etc.
Yes. That is there. That is there.
Well, then your lordship only consider page 40 of my activity in opposition upon my executive engineer.
Give me a minute, please. Several affidavits.
He will show.
Okay, consider করার জন্য বলেছি. It has been written addressed
Status
to the
report.
collector district. Prayer for Suchitra Rai.
Status.
Suchitra Rai for compensation.
With regard to the status report of the
Affidavit by Vikram Vishwas.
your lordship would find it from the writ petition also.
Subrata Dhar.
The executive engineer Alipur is the public health engineering.
It's there in the writ petition also. 49, page 49 of the writ petition, your lordship will find it from page 49. It's there. It's there in the writ petition, my lord. It's not disputed. That has been annexed by the petitioner, and we have also admitted that this is the document which was given to them.
For getting
The
compensation.
basis is admitted.
Thereafter, nothing has been done. No problem.
And it's a continuing cause of action, so question of delay doesn't
Now their prayer is, my lord, to make payment according to the present market price.
No, that cannot. It has to be done. The market rate prevailing at that period of time, my lord, that has to be taken into account.
Period. You have
When the land was
2023.
my lord,
You are remaining silent till 2023.
my lord, this was acquired in the year 2008. This proceeding was acquired in the 2008 too. 2008, my lord, and they come up with the writ petition in the year 2017, my lord. That has to be taken into account. That has to be taken into account.
I'll consider it.
My lord.
They have annexed the documents to that effect, my lord. Page 51 and 52.
Yes.
The assessment, my lord, from the public. That should be considered.
51, 52 is on as on
Market rate of the year 2016.
16.
If I'm not wrong, subject to correction, 2016 always, because 2016.
that
So only the period, my lord, they came up with this writ petition, my lord, that must be taken into account.
Rest is admitted.
Rate is and market rate, my lord, that has to be taken in 2008, rather than the year they have come up with this application.
You are claiming market rate from the date of institution of the writ petition. As on the date of writ
From
petition.
the date of my disposition, I want market rate.
Your disposition is 2008. You are claiming.
Supreme Court said 42 years.
You are
Permissible.
claiming market rate as on date of writ petition or date of writ petition যদি file করা হয়েছে।
As you lordship, please, I leave it to you, lordship. I leave it.
What is your prayer then?
I leave
Prayer
it.
কি দিচ্ছে? Prayer-
My prayer is compensation. Okay.
No, no, compensation, market rate as on. Anyway, I'll look, I'll see.
But they have prayed for present market rate. On the writ petition, they have present market rate, which is 2017.
That is where the writ petition.
When the writ petition was filed. And my only contention is that since they were since 2008 to 2017, they did not take any action. Now, that may be considered if
2015.
I'll leave it to your lordship. I'll leave it to your lordship.
Argument concluded, judgment received.
Present market cycle. হ্যাঁ, বলে দাও। অত হবে না। হয়তো তা নয়।
May I draw your lord? May I draw your lordship time, my lord, attention, my lord, to item number 533. 533. My lord, your lordship, my lord, what happened, my lord, on 27th September, it was called on. In absence of the other side, my lord, it was, my lord, fixed today. I am praying before your lordship, my lord, it may be upgraded on the next day after 2-3 matters.
It will come.
The lordship
I
kindly.
cannot keep mentioning now, it will come up. Judgment reserved.
Hello.
Yes?